Okay, good evening, everyone. Hopefully everyone can hear me. Welcome to week number 2 for our PPA 500 course. I believe that we are recording. Yes, we are. So I hope everyone's having a good week. And tonight, what we're planning on doing is we are planning on starting out by looking at the Constitution, kind of finish up this unfinished business from our last week together, and go through the Constitution, not necessarily with a fine tooth comb, not going through every word of the Constitution, but to just highlight some of the major elements of the Constitution that we all need to be very much aware of as public administrators, as well as just general citizens. We don't have many opportunities to look at the Constitution as a class. This is probably the only opportunity you will have in the DLMPA program to be able to do that. So the first part of class, we will talk about the Constitution, and then we will move into a discussion of accountability and ethics, and we'll talk about why sometimes it's difficult to hold administrators accountable. We'll talk about some of the differences between private sector values and public sector values and what those differing values mean for differing ethical standards between the two sectors. I will then introduce you to the American Society for Public Administration's Code of Conduct. We'll go through those 8 principles that we all share as a code of conduct with our public administration professional organization. And then I'll go ahead and wrap up with a really quick conclusion to our coverage of accountability and ethics. Then what I would like to do is I promised you last week, we didn't have a chance last week, but I would like to start using some breakout groups. And so I'd like to break you up into breakout groups near the end of class tonight, and then allow each group to discuss a recent or somewhat recent ethical violation that's been in the news, either an ethical violation or a scandal on the part of an administrator or elected official, other public official, and kind of link that scandal that the group selects back to those 8 principles in the ASPA Code of Conduct. And again, I think it's really nice that we do these breakout groups so that you'll get to work with different folks in the cohort throughout the course so that you'll get to know each other a little bit better and a little bit quicker. So that's our goal tonight. That's our agenda. But before we jump into that, let me just give you a couple of reminders. One reminder is that you have the Canvas essay number 2 assignment, which is due next week. For Canvas essay number 2, you're going to take the 8 principles in the ASPA Code of Ethics that we talk about tonight. You'll select 3 of those 8 principles that you feel are most challenging or would be most challenging for you or for a public organization, and then provide an essay on that. And of course, as always, responses to 2 of your classmates. And then also you have this initial skills self-assessment that is also due next week on February 12th. That initial skills self-assessment, again, just to reiterate, there are no right or wrong answers. It's not graded for the correctness, if you will, of the content. It's just an opportunity for you to talk about your experience or knowledge or comfort level with different aspects of the MPA program. So in part 1, you're just going to do an ordinal ranking from 1 to 5 in terms of how much you know about each of these different competencies or skills that you'll get in the MPA program. Then in part 2 of the initial skills self-assessment, you will focus on the 5 major core areas of budgeting, HR, org theory, policy, and research methods / program evaluation, and to give a 1 or 2 sentence narrative about your experience in each one of those 5 areas. Now, if you don't have experience in one of those areas or all of those areas, then just say, I do not have any experience, and that's good enough to suffice for an answer, because this is supposed to just be a very honest assessment of where you are at in terms of your skills entering into the MPA program. And then the third part is just a 1 paragraph. Why are you in the MPA program? Why did you select the DLMPA program? And what types of skills do you want to get out of the MPA program? Jasmine asked a question about the link. I responded just recently in the class cafe. Don't worry about that link. That's a link that used to exist for the core concepts in the program. It just kind of talked about budgeting, HR, and those 5 different areas. It's not necessary for the completion of the initial skills self-assessment, so don't worry about that. The college decided recently that they were going to centralize all the website design for all the departments within the college. And so they now have a bunch of new links, and some things are still on the website, some things are not on the website. And that was one of the casualties of that reorganization. So again, the initial skills self-assessment, it's credit, no credit. So no worries at all. Just make sure that you turn it in and you'll get your five, oh, I guess it's 10 for this class, 10 out of 10 points on that initial skills self-assessment. One other thing I want to alert you to is that on our Canvas site, under the module for this week, under module for week 2, I've included a link on there. I think it's called something like Public Administration Research Presentation. That is a video that was produced by our university librarian, Kelly Janicek. And Kelly Janicek, as our university librarian, is responsible for a variety of different fields, but primarily for public administration and political science. And so she did a presentation to one of the sections of 500, and that presentation is recorded. I want to make it available to you because in that presentation, she talks about some tips and tricks for doing research in public administration. She'll talk about different search words you can use and different, Boolean searches you can do, and some different strategies to help you narrow down searches in the databases that we have available here through CSULB. And she'll show you some databases such as PAIS, the Public Affairs Information Service. She'll show you databases such as ABI Inform, if you've ever used that before. And she talks in the video about the utility of those different databases and when to use one database versus another database. Also in that video, she talks about the importance of peer review. And granted, we don't do a whole lot of research in this class. This is just your introductory course. But in your future courses, you will be doing public administration related research. And so she talks to you about the importance of peer review articles. And in that research you do in future courses, you want to make sure that the sources you are using are peer reviewed sources. And peer review basically means that whenever a manuscript is submitted to a scholarly journal, that manuscript goes through a rigorous review process and is reviewed by multiple people. It's what we call a blind refereed process, whereby the reviewers do not know who that person is who wrote that article. There are no identifiers on the article, but you'll have 3 to 5 reviewers that will review every manuscript and will then make recommendations and a recommendation for a decision about publication back to the editor. And in a scholarly peer-reviewed article publication process, there are basically 3 different decisions that an author may receive when they submit a manuscript to a journal. The first one is accept. That is oftentimes not going to happen without any revisions, but that would just be we accept it kind of as is, with the exception of some typesetting types of changes. Of all the articles I published over the years, this happened to me twice. It's a pretty rare type of occurrence. What is much more common that you'll get is a decision called an R&R, which is a revise and resubmit. So the reviewers will say, here are some things that we would like for you to reconsider in your article. Maybe we think you should include an additional variable or two. Maybe we think you should think about using, binary logistic regression instead of multiple regression. And so they'll make those types of recommendations. And then those recommendations go back to the author. And it's up to the author whether or not they want to accept those recommendations and make those revisions to the article. If they do, then they make the revisions and then they submit that revised article back to the journal. And then that revised article then goes back to those reviewers and they will review it again. At that point, they could recommend publication to accept it for publication, or they could recommend more revisions. And so it would then go back to the author again for more revisions. In my experience, you basically get one set of revisions and you make those revisions, and then typically the article in the near future will then get published by that journal. There was one journal I published in, it's called Publius, the Journal of Federalism, which when we get to the Intergovernmental Relations course, we will read a lot of articles out of Publius. It's that top tier journal in the world of federalism. when I published in Publius, I had 3 or 4 rounds of revisions because it's a much more rigorous review process than a lot of other journals. So most people get an R&R revised and revise and resubmit. The other decision you can get is a rejection, where they just reject the article out of hand and say, we're not going to publish this. I haven't gotten one of those, but I think when you get those, you get them primarily because your manuscript doesn't fit the purposes of the journal. So they'll say, submit it to this journal. It doesn't really fit what we do here in this journal. But that's what's known as a peer-reviewed process of review. Obviously, the importance of peer review is that it makes sure that when the articles are published, that hopefully the methodology is correct, that the theories are appropriate, and that it is good, verifiable research. Now, as Kelly points out in her video, there have been some instances recently of journals finding out that some of the articles they published, the methods were falsified. And so then those journals have to go back and retract that article and remove that article from their database. And then anyone who used that article in doing research on the articles that they got published, their articles oftentimes get removed as well from those journals. So that's becoming more and more of an issue as it becomes easier and easier to check a lot of the data and the methods that authors are relying upon. But overall, peer review is really our best check to make sure that the research that we are basing our decisions on is good, verifiable, the research that can be replicated, so we consider to be reliable and valid research. So most of the resources you'll be using for your papers in this program will come from scholarly peer-reviewed journals. And some of the major peer-reviewed journals in public administration are things like Public Administration Review, the American Review of Public Administration, Publius, the Journal of Federalism. Those are some of the more the top tier types of journals in the world of public administration. If you come into this program from a different disciplinary background, a different undergraduate major, you may be surprised at the small number of peer-reviewed journals that we have in the field of public administration. As Kelly points out to you in the video, we have about 50 total public administration journals you would consider to be public administration in nature. You compare that to the discipline of political science, and political science literally has hundreds of political science journals. So we have far fewer in public administration. But if you want to make sure that the journal you're using is peer reviewed, one sure way to do it, foolproof way to do it, is to look at who is publishing that journal and then go to their website and look at the manuscript submission guidelines that will be provided for authors on their website. And again, you're looking for a blind refereed process whereby that manuscript will be reviewed by 3 to 5 anonymous reviewers. I serve as a reviewer on a few different journals. Journal of Public Affairs Education. I'm a reviewer on Teaching Public Administration. I used to be a reviewer on State and Local Government Review. So it's a lot of work for reviewers to go through these articles, because you really want to make sure before you approve an article that it is good, verifiable types of research. So she'll talk a lot about that in that video. Then she will also talk to you in the video about APA format. And as I told you in an orientation session, as well as I think we mentioned it last week, APA is the style manual that we use here in the MPA program. So it will be used in all courses throughout the entire DL MPA program. So it's good if you're not familiar with APA yet to start to become familiar with it. Always a good strategy to pick up the APA manual 7th edition. Make sure to get the 7th edition, because that's what we are on now. And the 7th edition is much different than the 6th edition. So in terms of currency, you really want to have that current edition for the APA manual. And just you can have it as you go through the program to refer back to as you are doing your research. But there are, obviously, when you go and get your articles through a database, you can request that the citation be provided to you and downloaded in APA 7th format. So it will give you the citation in APA format. always a good idea to double check it because sometimes the databases are a little bit wrong in terms of how their citations look, but you can actually request a citation in APA format. If you do not want to purchase the APA manual, there are some really good free resources out there on the web, and you may have used this one before, but it's Purdue OWL. Purdue University has a site called Purdue OWL, and oops, if I can spell OWL correctly. And you just jump on and Google it. And if you just Google Purdue OWL, it will then pop up there for you. And they have examples of how you cite journal articles and books and government documents and personal communications and interviews and websites and just about any place you're going to get information. Purdue OWL will show you examples of exactly how you cite all that information. So that's in the second half of that video. It's about almost an hour-long video. So I'd ask you if you could, sometime throughout the duration of this course, just go and take a look at that video, and I'll keep it up there on our Canvas site throughout the entire course so that you'll have it to go back and refer to. But I will also tell you that as you go through the program, you'll notice that some of our instructors are a little bit more sticklers when it comes to APA format. Some are a little bit less in terms of being sticklers. Typically in my courses, because you're going to have the misfortune, I guess, of having me again in organization theory as well as intergovernmental relations, I tend to be a little bit more on the lax side in terms of APA format. If your references are not in APA format, I will point that out and I'll say, well, here's what's wrong. You didn't italicize your journal titles, or you capitalize every word in your article title, which is not done in APA. So I'll tell you those types of things in terms of feedback, but I'm not going to deduct any points if it's not purely in APA format. I'm much more interested in the content as opposed to the format of papers that are submitted in my courses. Now, some other instructors are not like that. Some other instructors will deduct points if it's not in pure APA format. So it's good to get that manual, get familiar with APA format because you'll be using it over the next 22 months. But that video is up there for you so you can go and watch at your convenience. And again, great thanks to Kelly Janicek for doing it. She does a really nice job, and it's always better to have a professional librarian talk to you about research than it is for me to do it. So she is the expert in the field. Okay. Okay, I am going to, if you don't mind, I'm going to turn my camera off because with all the rain and all the weather, I've been having some internet issues. Again, I am at home today and I had a meeting earlier today on Zoom and there was a whole lot of buffering that was going on, and I hope that doesn't happen tonight. But as always, if for some reason I disappear, just stay in the session. The session will stay alive. And then as soon as I'm able to log back in, I'll log back in and then we'll pick up on whatever we may have missed. So don't go anywhere in case I disappear. All right. Okay, let's go ahead and get into our material for tonight, and starting out with our coverage of the Constitution. And as I said before, the reason why we spend time going through the Constitution is because as public administrators with qualified good faith immunity, we need to know and then endeavor not to violate the constitutional rights of citizens we come into contact with. So it's good that we have at least one forum throughout your next 22 months of the program where you can actually sit down and take a look at the Constitution. Hopefully you've been able to take a look at it. I do have the link up there on our Canvas site, and I don't want to belabor it too much, but to go through each of the articles in the Constitution, one of the things that you realize very quickly when you look at the Constitution is that the framers put together a very well organized document, in that there are 7 articles in the Constitution, and each article addresses different topics. So the first article, Article 1, which is by far the lengthiest and the most detailed article in the entire Constitution, looks at Congress. It looks at this legislative branch. And last week we talked about some of those conflicts that were going on at the Constitutional Convention, and then the various compromises that the framers came to try and mediate those conflicts. we're going to see a lot of those compromises right here, initially, right off the bat in Article 1 of the Constitution. So in Article 1, Section 1, you have one of those very first compromises, this creation of a bicameral legislature, creation of a House of Representatives, creation of a U.S. Senate. House of Representatives based upon proportional representation, kind of the Virginia plan part of it, and then the Senate based upon equal representation, a nod to the anti-federalist and more the New Jersey type of an approach. We get into Section 2 when we start talking specifically about the U.S. House of Representatives. And you're familiar with the requirements of being a House of Representatives. Members of the House only serve 2-year terms. That was done intentionally because the House is meant to be the lower chamber of Congress, and it's meant to try and be more responsive to the people. So through proportional representation, the people can then hold their members of the House of Representatives accountable for their actions because they're only serving these 2-year terms. A 2-year term goes by very, very quickly. And what it means in modern politics is essentially as soon as you are elected to a seat in the House of Representatives, you immediately start running for reelection. You immediately start raising money again and doing your speaking engagements and whatever it takes for you to get reelected. So members of the House are constantly running for reelection. To be a member of the House of Representatives, you have to be at least 25 years old. You must be 7 years a citizen of the United States, and you must come from the state in which you are being chosen. So the standard for being in the House, being 25 years old, is lower than the standard for being in the Senate, and certainly lower than the standard for being elected President of the United States. In Section 2 here, that third paragraph, this is what used to be known as the apportionment clause of the Constitution. That has obviously been removed as a result of subsequent amendments like the 14th Amendment to the Constitution, the 16th Amendment to the Constitution. But originally in the Constitution, paragraph 3, we had this apportionment whereby direct taxes needed to be apportioned among the several states. And essentially what happened is that taxes were apportioned according to state population. And this was another nod to the small states and to the anti-federalists, that the anti-federalists from smaller states were concerned that they didn't want to have to pay an equal amount to larger states that had more population. So here is that compromise that, well, larger states will pay more based upon their bigger population. Under this clause, which is now no longer operative, but under this clause originally, it meant that there was no direct federal income tax on individual income. So someone tells you the federal income tax is unconstitutional, they were correct all the way up until 1913. Then in 1913, we get the ratification of the 16th Amendment to the Constitution, which says that Congress may levy taxation on any source whatsoever without apportionment. Any source whatsoever is a very broad grant of power that allows Congress to basically apply taxes wherever they want to. So they were able to then have a constitutional federal income tax. They were then, if they want to, are able to have a constitutional sales tax, which they have not done yet, but they talk about just about every term of Congress. The first time Congress tried a federal income tax directly on the income of individuals was back in the Civil War to fund the operations of the Civil War. And that was not challenged as being unconstitutional. And so it kind of was in effect until the end of the Civil War. Civil War was over, and then that tax went away. Obviously, since there was a Civil War raging, no one really challenged it in the Supreme Court. But then Congress tried to do it again in the very late 1800s. And this time, when they tried it again, someone challenged its constitutionality. It was declared to be unconstitutional. And that's what then led to the 16th Amendment. One of the checks on judicial power that Congress has is if the judiciary decides that an act of Congress is unconstitutional, Congress can then just propose an amendment to the Constitution and get that amendment ratified by 3/4 of states, and then therefore that automatically then makes that action constitutional moving forward. Unfortunately, in this apportionment clause of the Constitution, we also then have the 3/5 compromise. And this three-fifths compromise, as we talked about last week, was the compromise to try and mollify the slave states so that enslaved people would count as three-fifths of a free person for the purposes of representation in the House of Representatives. Obviously, again, that was then removed from the Constitution as a result of the 14th Amendment. We also talk about this enumeration when we know how many people we have in the country, and it established this requirement for having an enumeration every 10 years. This is why we have a census once every 10 years. An actual enumeration, actual counting of the population is because it's right here in Article 1, Section 2 of the Constitution. There was a challenge. No, there have been a few challenges, but there's a challenge in the Clinton administration to the way in which the census was conducted, in that the Clinton administration wanted to use statistical sampling, like the Census Bureau uses for all the other types of research that they do. And so they wanted to put together a representative sample and extrapolate those results for the enumeration. That was struck down because the Constitution clearly says an enumeration, which is a counting of the number of people in the country. And then, not to belabor too much, but we also had a couple of challenges in the Trump administration as well in terms of how this census would then be conducted. Also, here in this section of the Constitution of Article 1, we also talk about how vacancies are filled, and the chief executive in the state may fill vacancies in the House of Representatives. This provides that power then to governors, and this is why governors can make appointments until an intervening election or an intervening special election. And then we also identify the one constitutional office in the House of Representatives, and that is Speaker of the House. The position currently occupied by Mike Johnson from the state of Louisiana, previously held by Kevin McCarthy from California. Speaker of the House is a constitutional position, and it is then essentially second in line to the presidency. And so first in line to the presidency is the vice president, second in line is the Speaker of the House, and then third in line would then be the president pro tem of the U.S. Senate. And speaking of the U.S. Senate, in Section 3 of Article 1, we then turn our attention to the U.S. Senate. Senators serve much longer terms than members of the House. They serve 6-year terms as opposed to 2-year terms. Now, if you want to contrast this then to what goes on here in the state of California with our state legislature, in our state legislature, in the state assembly, members of the state assembly serve 2-year terms. Members of the state Senate serve 4-year terms. Here in California, we have term limits placed upon our representatives, but there are no term limits in the Constitution, federal Constitution, placed upon members of the House and members of the Senate. So you can basically serve in the House and serve in the Senate as long as you're able to get reelected. Here in California, our current limitation in term limits is an overall limitation of 12 years. So you can only serve overall 12 years in the state legislature, divided up however you divide it up between the Assembly and the Senate, but only an overall 12 years that you can serve in the California state legislature. That's courtesy of a constitutional amendment known as Proposition 28. Proposition 28 replaced our old term limits, which came from Proposition 140. And back in Proposition 140, we placed limitations on the number of terms you could serve in the Assembly and number of terms you can serve in the Senate. So back under Prop 140, you could only serve 3 2-year terms in the Assembly and 2 4-year terms in the California State Senate. Now it's an overall limitation of 12 years, regardless of which body you are serving in. The Constitution, Section 3, also then immediately upon the coming together of the Senate, and we then have this provision to divide the Senate up into thirds, because you don't want all seats in the Senate coming up for re-election at the same time like they do in the House of Representatives. You want to have some type of continuity of government. And so we divide the Senate up into thirds. And so the way in which it works today, a third of the Senate comes up in 1 year, and then 2 years later, another third comes up, and then 2 years later, another third comes up. So you don't have all 100 senators sitting for re-election at the same time. As we said, the limitation to serve in the Senate, you have to be at least 30 years old and you have to be a citizen for at least 9 years. And then again, you have to be an inhabitant of the state in which you are chosen from. We know that the Vice President of the United States serves as the President of the Senate, but may only vote in the case of a tie. Historically, Vice Presidents have not voted much because there haven't been a whole lot of ties in the Senate. When you think about the Senate and party distribution in the Senate today, essentially you have, for practical purposes, a 51-49 split, where you have 51 senators who typically caucus with the Democrats, 49 senators who typically caucus with the Republicans. However, in that number of 51 senators who caucus with the Democrats, we can't forget that 3 of those individuals are independents. They're not Democrats, they're independents. Angus King from the state of Maine is an independent. Bernie Sanders from the state of Vermont is an independent. And Kristen Sinema from the state of Arizona very recently has become an independent as well. So you really have 48 Democrats, 49 Republicans, and 3 independents who vote and caucus with the Democrats. That is a very close split right down the middle in terms of party representation, which means there's a potential in reality for a lot more ties in the US Senate. And Vice President Harris recently set a new record for the number of tie-breaking votes by a vice president with 33. So she has made 33 tie-breaking votes. The old record was held by John C. Calhoun, who had 31 tie-breaking votes, and that dates all the way back to the John Quincy Adams and Andrew Jackson administrations. John C. Calhoun served as vice president for the end of the John Quincy Adams administration and then for the beginning of the Andrew Jackson administration. So we've seen a lot more party division within the Senate and therefore more tie-breaking votes by the vice president. And I think you make an argument, she's probably not done yet. And there probably going to be some more tie-breaking votes coming up over the next year. The Senate also gets to choose its own officers like the House does. The constitutional officer spoken of in the Senate is this position known as the President Pro Tempore. We usually just call it the President Pro Tem of the Senate. The President Pro Tem of the Senate is typically the longest serving member from the majority party. And so the current President Pro Tem of the Senate is Senator Patty Murray from the state of Washington. And so Senator Murray is now fourth, well, technically, I guess she'd be third in line for the presidency. So you have Vice President, you Kamala Harris, you then have Speaker of the House Mike Johnson, and then you have President Pro Tem of the Senate Patty Murray. From there in the line of presidential succession, you then go through cabinet positions, beginning with the oldest cabinet department. So you look at the oldest cabinet department, Secretary of State, and then that person would then be next in line for the presidency, as long as that person meets the qualifications of being 35 years old and being a natural born citizen. So we have instances where the cabinet secretary who would be next in line for the presidency is not then eligible to become president. Where the House has the sole power to impeach presidents and other executive and judicial officials, the Senate has the sole power to then conduct trials for those impeachments. So the way in which it works, we saw this twice in the President Trump's administration. We saw this once in President Clinton's administration. We saw this once way back in the 1860s in President Andrew Johnson's administration, whereby the House of Representatives has impeached the president. An impeachment is essentially similar to an indictment. So the House will pass articles of impeachment. Those articles of impeachment, once they are passed by the House, then go over to the US Senate, and then the Senate has the responsibility of then conducting a trial. When the Senate conducts that trial, all senators then must say an oath, be sworn in with an oath before they serve as essentially jurors, is what they are doing during that trial. And then you'll have managers from the House of Representatives who will bring those articles of impeachment over, and then they will kind of act as the prosecutors in that trial in the Senate. Then the president who is being impeached can have their lawyers there to serve as the defense lawyers. And then the presiding judge is the Chief Justice of the Supreme Court. So Chief Justice Roberts served as the presiding officer in the two impeachment trials for President Trump. William Rehnquist served as the presiding officer in the Clinton administration in his impeachment trials, or trial singular. So we know that President Trump, in both of his impeachment trials, he was not found guilty and was not removed from office. Same thing with President Clinton. Back in the 1860s with Andrew Johnson, he also was not found guilty, but he survived by one vote. And there was one senator who switched votes from yes for impeachment for removal to no for removal. And that one switch of a vote is what then saved Johnson and kept him in the office of the presidency. In order to remove a president or another executive official on impeachment, you need to have a 2/3 vote of members of the Senate. So it's a very high standard. When you think of a Senate that's really divided 51 to 49, getting that 2/3 vote is oftentimes next to impossible. We did see in the news recently that the House tried to pass articles of impeachment against Mayorkas, and they failed to do so. So it's not just the president, but cabinet level officials technically can be impeached. Other executive officers, judicial officers, members of the federal judiciary can also be impeached and removed from office as well. Section 4 then talks about elections, and here we have what's come to be known as the Elections Clause. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. So states have the ability to control their own elections. However, the rest of that section then reads, but the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. So Congress can come in and change those decisions made by states in terms of organizing elections for members of the U.S. Senate and the House of Representatives. Congress must assemble at least once every year. We know that we have a very professionalized type of Congress, and so they certainly meet a whole lot more than that. Here in the state of California, our state legislature is also a very professional state legislature, in that it's a professional full-time legislature. We have 40 members of the California State Senate. We have 80 members of the California State Assembly. Of those 40 members of the California State Senate, 32 of those members are Democrats, 8 are Republicans. In the California State Assembly, of those 80 members, 62 of those are Democrats and 18 are Republicans. And so we very much have one party rule, a very unified type of government here in California, as opposed to the tradition of divided government, where you have the House and the Senate controlled by different parties in the at the federal level. Section 5 then talks about how the House can, each House, the House and the Senate can control their own elections and can, if they want to, discipline members. And also, if they want to, they can also remove a member, they can expel a member with a 2/3 vote. And we saw that happen recently in the House of Representatives with the expulsion of Representative Santos from the state of New York. So we have a very recent example of Congress expelling one of its own. Both the House as well as the Senate maintain journals, and that's important because the journals have come to be what we refer to today as the congressional record. And so if you ever watch C-SPAN for whatever reason, maybe you like to watch debate, and whenever a member gets up there and asks, I would like to revise and extend my remarks, that's the member saying anything that I don't have time to say here at the lectern on the floor, I would like to then publish in the congressional record. Because in the House of Representatives, time is very closely monitored. And so you may get 30 seconds to speak on the floor of the House. And you may have a lot more to say than what you can say in 30 seconds. You revise and extend your remarks, it then goes into the congressional record. Let's see, Section 6 then talks about that members of Congress can then get compensation for their services. There's also what's called the emoluments clause here, whereby members of Congress, just like the president, cannot get compensation outside of their normal salary. So you can't go out there and collect rents on on properties that you own or collect, capital gains and things such as that. You have to have your salary, and then any types of stocks that you own are then supposed to go into a blind trust so that you don't have any control over how those stocks are being traded. So most members will create that blind trust and then or they're supposed to, and then take hands off of that blind trust and then allow a trustee to then operate that blind trust. You're not allowed to hold another civil office while you are in Congress. So you can't have your position in Congress and then also serve as Secretary of State. You can't do both of those jobs. You're going to have to pick one of them. Section 7, an important part here in Section 7 is this idea of bills that raise revenue. So any piece of legislation that raises taxes, raises revenue, must begin in the House of Representatives. And again, that was done by design by the framers. Because the House was closer to the people, they figured people would be very interested in any bills that would cost them more money. And so they could hold members of the House accountable much easier than members of the Senate. Also in Section 7, we stipulate that before a bill can go to the president for their signature, that bill must first be passed in the House and the Senate in identical version before it then goes to the president. What that means is that we have this system of conference committees. And so, as you know, a bill comes out of the House, it looks a lot different than the bill that comes out of the Senate. So then we have to convene this conference committee. That conference committee then hammers out the differences between the House and the Senate bills. The bills then go back to the House and the Senate for final passage before they can then go to the president for their either signature or for their veto. In terms of vetoing, if a president vetoes a bill, that veto can then be overturned with a supermajority of the House and the Senate. It's especially difficult to overturn a presidential veto. Very few presidential vetoes get overturned. It's not unusual for a president to go through their entire 4-year term and never have one of those vetoes overturned by Congress. Getting that supermajority is incredibly difficult, especially when you have a very closely divided Congress like we currently have today. Article 1, Section 8. If you've done any constitutional studies before, you know all about Article 1, Section 8. This is the lengthiest, most detailed article that we have in the Constitution. In Article 1, Section 8, we lay out the powers of Congress. So here is where we have this major compromise between the Federalists and the Anti-Federalists. Federalists want to give Congress and the national government more power under the Constitution. Anti-Federalists wanted some protections to limit congressional and national power. We get both of those things here in this compromise in Article 1, Section 8. So in Article 1, Section 8, we list certain powers for Congress. Congress may lay and collect taxes. Congress may borrow money, and we're painfully aware of how good Congress is at borrowing money. They borrow a whole lot of money. Congress has the ability to regulate commerce with foreign nations and among several states. This is a very important enumerated power that's going to be known as the Commerce Clause. Commerce Clause says that Congress has the ability to regulate trade that's going on between the states. So trade that crosses state borders, that is something that Congress has the ability to regulate. When Congress wants to increase its power over state governments, it typically utilizes this Commerce Clause. Then it's up to the Supreme Court to decide whether or not the utilization of this Commerce Clause is truly constitutional. Supreme Court has to look and say, well, Congress, did you bend the rules a little bit? Does what you are ordering states to do, does this really have a direct connection to interstate commerce, what the court calls a interstate commerce nexus? And there have been some instances in the 1990s where the Supreme Court has said, Congress, you can't do this, because what you're ordering state government to do has nothing to do with interstate commerce. And so therefore, you cannot do this constitutionally. At other times in our history, like in the Wickard-Filburn case, the Supreme Court has said, yeah, Congress, you can do it, even if this good, at that time, in that case, it was wheat, even if the production of this wheat is not even crossing state boundaries, this wheat is not even being sold, it doesn't matter, Congress still has the power to do it. So the Supreme Court has come to various conclusions in terms of just how expansive this commerce power is for Congress. So I really can't overemphasize how important the Commerce Clause is for congressional national government power. Congress has the ability to establish uniform rules of naturalization. They have the ability to coin money. Remember, that was a problem under the Articles of Confederation, to provide for punishment and counterfeiting of securities and money, to establish post offices. And that's why we have a U.S. Postal Service. Congress has the ability to establish these post offices, to promote the progress of science and the useful arts. We have a National Science Foundation. The reason why Congress supports those things is because they have this requirement to promote the progress of science and the arts. To constitute tribunals inferior to the Supreme Court. This is a huge power that Congress used in the Judiciary Act to create the entire federal judiciary underneath the U.S. Supreme Court. Supreme Court is the only court that's mentioned in Article 3 of the Constitution. Every other court inferior to the Supreme Court is established by Congress through that Judiciary Act. And so all those federal trial courts, district courts, all those federal courts of appeal, those were all created by congressional action. To find, punish piracies and felonies on the high seas, to declare war. Only Congress may declare war. Now, presidents may send troops into military engagements overseas, but if the president really wants to have a declaration of war, they need to go before a joint session of Congress and ask Congress for an official declaration of war. That happened in World War I. That also happened in World War II. In World War I, there was a good bit of opposition to a declaration of war in Congress when that was requested. So there were some members who voted against it. In World War II, there's only one member who voted against a declaration of war, and that was a representative by the name of Jeannette Rankin. And Jeannette Rankin was the same Jeannette Rankin that voted against a declaration of war in World War I. So there's a little piece of trivia for you. That's the one person who voted against both declarations of war. So the president has to go and ask Congress for that declaration of war. Congress has the ability to raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years. Now, obviously, we have a standing army today, but Congress has the ability to raise and support armies, to provide and maintain a navy, to make rules for the government and regulation of the land and naval forces, provide for calling forth the militia, to provide for organizing army and disciplining the militia, to exercise exclusive legislation in all cases whatsoever over such district, meaning the District of Columbia, where the capital will be located. That DC is under the control of Congress, even though it is a city and even though it has a mayor, it's ultimately under the control of Congress. And then we get to the end of Article 1, Section 8. So up to this point in Article 1, Section 8, we have been enumerating, we have been listing specific powers of Congress. Now, once we're done listing those specific powers, we now have the elastic clause. That Congress, to make all laws which should be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or any department or officer thereof. So Congress can do whatever it considers to be necessary and proper that will allow it to carry out all these enumerated powers that have been listed in Article 1, Section 8. This, as we talked about last week, is a major compromise between the Federalists and the Anti-Federalists. The Anti-Federalists got an enumeration of powers to limit the power of Congress. Then the Federalists got this elastic clause, this catch-all, that greatly expands the power of Congress. When Congress wants to expand its power over states, Congress typically does that through the combination of the Commerce Clause and the Elastic Clause. So those are the two clauses that we tend to see in Article 1, Section 8 that Congress relies upon when it wants to exercise power over state and local governments. Since we give certain powers to Congress in Article 1, Section 8, we also then have to limit those powers to, again, placate the concerns of the Anti-Federalists. And so we get that in Article 1, Section 9. So here are the things that Congress cannot do. Congress cannot pass a law to ban the slave trade until at least the year 1808. Again, this was that terrible compromise, like the Three-Fifths Compromise, in order to try and placate slave states. And so the balance was putting these provisions in the Constitution and then avoiding having the institution of slavery itself sanctioned within the Constitution. And that was kind of this trade-off that the framers made. The privilege of right of habeas corpus shall not be suspended. And you all know habeas corpus means literally to present the body. And so if you arrest someone, you must declare where that person is, what that person is being charged for. You can't arrest someone and then just stick them away in a jail someplace and no one knows where they are, unless there is a case of rebellion or invasion that the public safety may require it. In the Civil War, we saw Congress and President Lincoln suspend writ of habeas corpus, argument being that you can't have much more of a rebellion than an entire civil war. No bill of attainder or ex post facto law shall be passed. A bill of attainder is when we declare someone to be guilty without the benefit of a trial. So we just say you are guilty, but you don't get a trial. That's considered to be a bill of attainder. Congress cannot do that. Ex post facto law is an after the fact law. So if you do something yesterday and it was legal, then today Congress decides to make it illegal, and then you get prosecuted for doing it what you did yesterday when it was legal. You can't have a law that retroactively makes something illegal and makes something a crime. That's an ex post facto law that is not allowed. We're not going to go through all, but there are a lot of these limitations that are placed upon Congress, again, to try and placate those anti-federalists who are concerned that Congress and the national government would just become too strong. Then in Article 1, Section 10, we then place limitations upon state governments. And so we say specifically, here is what states cannot do. States may not enter into treaties. And we'll see in Article 2, treaties must be entered into by the president with the advice and consent of the Senate. So this is a national role entering into treaties. States are not allowed to do it. States cannot grant letters of marque or reprisal. A letter of marque or reprisal, in case you're interested, is the government basically deputizing people who own private ships to go out there and attack and pillage the ships of other countries. So they're basically, privateers and giving them government authority to go out there and be privateers on the seas. States cannot do that. States cannot coin money. Again, we want to get away from all these different currencies and have one uniform, unified currency. And then you can read through the rest. The states cannot pass ex post facto laws. They cannot pass bills of attainder. Cannot suspend writ of habeas corpus. They cannot grant titles of nobility, just like Congress cannot grant a title of nobility. So there are no sirs or knights or anything like that, like we see in other European countries. And other limitations there in terms of the ability to lay imposts, duties, and taxes on imports and exports. And you can read through those on your own. But the important thing here is we're not just saying in Article 1, Section 9, here are limitations on Congress. In Article 1, Section 10, we're saying here are limitations on what state governments cannot do as well. So you see there's a whole lot of detail in Article 1 of the Constitution, all oriented around the creation of this bicameral legislature known as Congress. Much different than the lowercase Congress that was used in the Articles of Confederation, just referring to a meeting. Now we have this permanent structure in place as of Article 1. Article 2, as you all know, turns its attention in the Constitution to the presidency and the executive branch. To be president, you'll serve a 4-year term as president, as opposed to 2 in the House and 6 in the Senate. The president has a 4-year term. Presidents have to be at least 35 years old, and they need to be natural-born citizens in order to qualify to be president. Another requirement is they have to be residents for at least 14 years. So 35 years old, resident for 14 years, and you have to be a natural-born citizen. So you can't be a natural-born citizen. You move overseas and then move right back again before you run for president. You have to have some residency established in the United States. So that kind of makes it a unique position in that it's a natural born citizen that has precluded some folks among the several candidates over the past several years who have not been able to become president. Arnold Schwarzenegger technically could not become president because he is not a natural born citizen. As I said before, some of our secretaries of cabinet level departments, even though they're in the presidential succession line, cannot become president because they are not natural born citizens. We lay out in Article 2 the Electoral College. And I'm sure you're all familiar with the Electoral College. The framers had a couple of concerns that they needed to deal with in terms of how presidents were being elected. One concern they had is they had a concern for the power of states. And they wanted to, again, placate the anti federalists by giving the states a role to play in the selection of the president. If you just had the president being selected just by national popular vote, then the states really don't have a role to play. However, in this electoral college, by saying each state gets its own number of electors equal to the number of representatives in the House of Representatives plus the number of senators in the Senate, which would be two, you are guaranteeing essentially that every state will have at least 3 electoral college votes in order to elect the president. So you're giving some representation to state governments. Also, a second reason for the Electoral College is the inherent distrust that the framers had in the decisions being made by average ordinary citizens. They really envisioned these electors in this Electoral College being people who were very well versed in politics, well versed in government, and so they trusted them a bit more than they would trust just a average ordinary American in selecting such an important position as the position of president. Now, as the country has grown, we know that our electoral college today consists of 538 electors. And so when you go and you vote in the presidential election, the general election, you'll see the name of the candidate you're voting for. But what you're really voting for is you are voting for their slate of bound electors. And so every candidate on the ballot will have a slate of electors. And so whenever that candidate wins the popular vote in that state, in 48 out of the 50 states, it's winner take all. So they then win all of those electoral votes, and all of their electors will then go to the state capitol in December and will then cast their votes ostensibly for that candidate. We have had some instances in the past where we've had what we call unfaithful electors, electors who are bound to one candidate, then they go to the state capitol in December and they vote for someone else. That's called an unfaithful elector. Some states have civil penalties for unfaithful electors, and a lot of states are now cracking down a lot more on those unfaithful electors. To win the electoral college, you have to get a majority. So now a majority electoral college is 270 electoral votes. So we have seen situations in which the result of the electoral vote looks different than the result of the popular vote. We saw that in 2016. We saw that in 2000 with the Bush v. Gore election. That does happen. But the person who wins the electoral vote becomes president, irrespective of whether or not they lost the popular vote. If no one gets a majority in the electoral college, then the election goes to the House of Representatives, and the House of Representatives will then select the president. That has happened in our history. It's not a terribly recent experience, but it has happened. One of the most controversial times in which the election went into the House of Representatives was what was called the corrupt bargain, and that was the election between John Quincy Adams, Andrew Jackson, Henry Clay, and there were 4 or 5 candidates that were running. They split the vote, and so Andrew Jackson got more popular votes than anyone else. He also got more electoral votes than anyone else, but he did not get a majority in the electoral college. So the election was kicked into the House of Representatives, and the John Quincy Adams made a deal with Henry Clay and said, if you give me your electors and you'll give me members of Congress who will support me, then what I will do is I will then give you a cabinet seat. And so those delegations then that were going to support Henry Clay then supported John Quincy Adams, which gave him enough votes in the House in order to become president. After he became president, he then appointed Henry Clay as his Secretary of State. That's the reason why it became known as the corrupt bargain. Whenever the House decides this election, they do it as congressional delegations. And so each individual member of the House does not have one vote. Each congressional delegation gets one vote and then must cast that vote as a delegation. So all of the members from California in the House, 53 or so members, they all have to then get one vote, all of them together. So they have to then come to a decision about which candidate they're going to support, and then California gets one vote. And that's the same way for each one of the states. We still have the Electoral College today, but there are several states that are trying to modify the Electoral College so that instead of awarding their electors to the winner of the popular vote in their state, they will award electors based upon who wins the national popular vote. And California is one of the signatories on this initiative. And as soon as you get enough states to add up to 270 electoral votes, then the electoral college will change. And then you'll have states giving their electors based upon the national popular vote rather than the popular vote in their state. Currently, 48 out of 50 states have a winner take all system that if you win the popular vote in the state, you get all that state's electors. The two exceptions are Nebraska and Maine. And in Nebraska and Maine, they award electors based upon who wins congressional districts. And so you have to add in the congressional district in addition to then who won the popular vote within the state. So they're not winner take all systems. So the Electoral College, as it was designed here in Article 2, certainly has been changed over the years. It certainly has grown in size, and it may be facing some significant changes in the future. So we have all these requirements for the president in order to serve as the president. We also have a very similar emoluments clause whereby presidents cannot receive emoluments, cannot receive these payments outside of their normal compensation. And then here at the end, we have this oath that presidents must say. And this has become a bone of contention recently. I don't want to get into it too much, but the oath is right here in the Constitution. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. This was somewhat controversial in the inauguration of Barack Obama, in that Chief Justice John Roberts screwed up the oath at the inauguration and didn't say it correctly. He was so concerned about that that he insisted that he meet in the Oval Office with Obama and give him this oath again and make sure he read every single word, because he felt it was in the Constitution. And if he didn't read the oath correctly, then perhaps there would be a question constitutionally about whether or not President Obama was actually the president. Also today, there's a question about the wording of the oath. That you're aware of these the cases that former President Trump is experiencing right now, and even tomorrow, if you're interested, if you're not working, or if you're at home and you have access to TV or radio, the Supreme Court will be live streaming some of the arguments in the California ballot access case that has been brought by former President Trump to the Supreme Court. The Supreme Court will be hearing oral arguments to determine whether or not they are going to take that case and whether or not they're going to render a decision on that case. That case is based upon the 14th Amendment, Section 3 of the 14th Amendment, that says that you can preclude someone from holding office if that person engaged in an insurrection or rebellion, and to not support the Constitution, essentially. So the question is, does the president, when the president becomes president, does the president commit to supporting the Constitution? Members of the House and Senate, in the oath that they say, their oath says support the Constitution. Former President Trump says when you read the oath of in Article 2, it does not say support. It says faithfully execute the office of the president will, to the best of my ability, preserve, protect, and defend, but it does not say support. So the oath said by the president is different than the oath said by members of the House and the Senate. And so the question then is, does Amendment 14, Section 3, then apply to the president? So it'll be very interesting to see some of the arguments that come out of the Supreme Court during oral arguments tomorrow. So that is a live stream. And I think it starts at 7 a.m. if you are interested. Section 2, we then started laying out some of the powers and duties of the president. As we know, the president wears many hats. The president is commander-in-chief of the armed forces. That was very important for the framers to have a civilian in charge of the military. That was a very important thing for them. And so that's one of the first things we get here in Article 2, Section 2 of the Constitution. We also know that presidents may require the opinion in writing of principal officers in each of the executive departments. This places the president at the head of the executive branch. So not only is the president commander in chief, the president also chief executive of the federal bureaucracy. The president also has the ability to grant pardons, and that has sometimes become very controversial with presidents. At the end of the Clinton administration, former President Clinton issued some controversial pardons. We saw some controversial pardons at the end of the Trump administration as well. Presidents have the ability to enter into treaties with the advice and consent of the Senate, provided 2/3 of senators present concur. So you have to have 2/3 approval by the Senate to approve of this treaty that you enter into as president. The very first treaty that President George Washington entered into, he assumed that the Senate would just be a rubber stamp. And so he literally walked the treaty over to Senate chambers, sat down outside of the Senate chambers, and waited for the Senate to approve the treaty. He waited there for 2 hours, then turned into 3 hours, and then finally someone came out and said, Mr. President, it may take us another day or two to review this treaty and to provide our approval, which outraged George Washington. He got up, he stormed away, and he never went back to visit Congress again. So that's not the way it works. The Senate has the ability to take their time in reviewing these treaties, and then they have to provide their 2/3 concurrence in order for that treaty to become official. We also know the president has the ability to appoint executive officials. Some of those executive officials then are also subject to Senate approval. You can see then if the president wants to fill some vacancies, then he can do it during what's called a recess appointment. If Congress is in recess, the president may fill a vacancy, make an appointment while Congress is in recess, which will be good until the expiration of the next session of Congress. And then would have to fill it with a permanent person. Section 3 also says that the president must give a State of the Union address, essentially must inform Congress about the State of the Union, as the section says, from time to time. Now, modern times, this has become an annual thing. So presidents sometime usually in late January or early February, sometimes it slips to March, but will go before a joint session of Congress and say, the state of our union is strong, and then make a very long speech to Congress. And then you'll have the opposition party then give a rebuttal afterwards. That informing Congress of the State of the Union, that comes straight from Section 3 of the Constitution. Again, the president must take care that laws are faithfully executed, again, making him the chief, or making them the chief executive at the head of the executive branch. And one thing we oftentimes overlook here in Article 2 is that the president also has the ability to recommend legislation to Congress for its consideration. That means that the president can recommend legislation and say, Congress, here is legislation from the White House. We want you to consider this. Presidents do that all the time. That makes the president what we would call the chief legislator. So if you look at all the hats the president wears, they are the commander in chief. They are the chief diplomat in terms of entering into treaties. They are the chief of state in that they inform the Congress about the state of the union. As we said, they're the chief executives, as they're in charge of the executive branch. And they have to make sure that laws are faithfully executed. And they are chief legislators in that they are recommending legislation to Congress. And so there are a lot of hats that a president wears in Article 2. Andrew Jackson made the argument that a president, as the only nationally elected figure, that presidents are the first branch of government, and that they should be preeminent over Congress and the judiciary, over the Supreme Court. A lot of political scientists will take issue with that. A lot of political scientists will make the argument that since Congress is discussed in Article 1 of the Constitution, Congress is the first branch of government. But this is this separation of powers tug and war tug of war that we see all the time in terms of the balance of power horizontally across our three branches of government. Then section 4, we have the stipulations for impeachment and removal from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors. We have a pretty good idea of what treason is. We have a pretty good idea of what bribery is. Where we argue a lot is, what did the framers mean by high crimes and misdemeanors? And oftentimes, if you want to know what the framers meant by the language they use, you can look at their other writings, such as the Federalist Papers, and you can see what Hamilton and Madison meant when you read those Federalist Papers. And again, most of this Constitution was written by James Madison. He wrote 29 of the Federalist Papers, so there's a whole lot of insight there for us. In terms of high crimes and misdemeanors, there's less insight into what they meant by that term. Today, misdemeanors has a very specific term for us. You have a misdemeanor or you have a felony, and certain crimes are categorized as misdemeanors. Some are categorized as felonies in federal law as well as in state law. For the framers, the word misdemeanor didn't have that type of categorization. And some historians will argue that it's a term that was borrowed from British case law. They liked the sound of it. It had been used in British courts, and so they just kind of brought the term misdemeanor over with them. But it's a big question about what is a high crime, what is a misdemeanor, what then qualifies a president to be impeached, and then eventually removed from office with a 2/3 vote of the U.S. Senate. Article 3, we oftentimes say talks about the judiciary, but really what Article 3 talks about is the Supreme Court. So it establishes one court, the Supreme Court, and then all inferior courts below that are created by Congress and were created by Congress in the Judiciary Act. We don't get a whole lot of detail here in Article 3, whereas we had detailed specifications for who can serve in House, who can serve in the Senate, who can be president. We have no qualifications listed here for who can serve on the Supreme Court. So there are no age limitations. There's no limitation in terms of even being a lawyer to serve on the Supreme Court. You are just nominated by the president and then you are confirmed by the Senate. Article 3 does lay out jurisdiction. And it talks about the jurisdiction of the Supreme Court. And just to kind of boil it down into the nitty gritty, essentially there are two different types of jurisdiction. There's appellate jurisdiction and original jurisdiction. With original jurisdiction, the Supreme Court can get a case directly. So a case can go directly to the Supreme Court. It doesn't have to percolate and make its way up through the federal judiciary. That is extremely rare. That does not happen very often. 99.9999% of cases, when they get to the Supreme Court, get there through appellate jurisdiction. So they go from a trial court decision up to the Court of Appeals and then get appealed to the Supreme Court. The Supreme Court obviously does not have to take every case that comes to it on appeal. And the Supreme Court takes a very small number of those cases that it receives. For the Supreme Court to accept the case, it must issue what's called a writ of certiorari, oftentimes called a writ of cert. A writ of cert means the Supreme Court met and a majority of the members of the court said, yes, we will accept this case for oral arguments. No cameras in the court, obviously, today, and so you don't get to see those oral arguments. You do get to hear them. That beginning with COVID, the Supreme Court, to be more open, decided that it wanted to start live streaming a lot of its important decisions. It live streamed, not decisions, but oral arguments. It live streamed the oral arguments in the Sebelius case, which was the test of the Affordable Care Act. And again, as I said, it's live streaming this ballot access case that it will be hearing oral arguments on for tomorrow. But again, not a whole lot of detail there, just the creation of this Supreme Court and its jurisdiction. I know this is taking some time, so I'll try and speed up a little bit for you. As we get through these articles tend to get a little bit more smaller and a little bit more concise and succinct as we go. The fourth article of the Constitution, Section 1, lays out this provision known as full faith and credit. We'll talk a lot about this when we get to our intergovernmental relations class, but full faith and credit pretty much means that a state must provide full faith and credit. It must respect laws and proceedings of other states. This was something that obviously anti-federalists were very concerned with. They wanted states to still kind of be considered sovereign entities so that they could all have their own sets of laws, but they would respect each other's laws. They don't have to adopt each other's laws, but they have to respect each other's laws. Article 4, Section 2, provides for us that citizens of a state, of all states, are then entitled to the same privileges and immunities of citizens in the several states. And so you have to kind of have the same types of civil liberties and protections regardless of what state you are in. Section 3 then talks about how we admit new states into the Union. New states may only be admitted into the Union by an act of Congress. And so we had this movement a few years ago. I think we're actually having it again here in California to try and break California up into multiple states. That's all well and good. The voters can go to the voting booth and they can vote to break California up into more than one state. But for those new states to be admitted into the Union, they would have to be admitted into the Union by Congress. So Congress would have to agree before it would actually happen. Section 4 is important. In Section 4, the United States national government guarantees to every state a Republican form of government. And as we talked about last week, Republican form of government means that you have a form of government whereby you can elect your representatives. They also commit to protecting the states in the case of an invasion. So there's your national defense that comes in as well to kind of mitigate some of the concerns that both anti-federalists as well as federalists had at the Constitutional Convention. Article 5 then talks about how we amend the Constitution. Remember, one of the major fatal flaws in the Articles was the inability to amend the Articles. We needed to have a unanimous vote of all states to amend the Articles. Here, we don't have to have a unanimous vote. So what Article 5 actually does is it lays out for us 4 different ways in which we can amend the Constitution. Now, even though there are 4 ways to amend the Constitution, we have only used one. We use approach number 1 all the time. We've never used approaches 2, 3, and 4. Approach number 1 that we use all the time is that an amendment may be proposed by 2/3 of the House and Senate and then ratified by 3/4 of state legislatures. That's the approach we have used for all of our amendments to the Constitution. A second approach that is there that we never use is an amendment can be proposed by a 2/3 vote of the House and the Senate and then ratified by 3/4 of state constitutional conventions. So you have a constitutional convention at the state level to then vote to ratify or not ratify those amendments that have been proposed by Congress. The third approach, you have 2/3 of the states petition Congress for a national constitutional convention. Then any amendments that come out of that national constitutional convention would then need to be ratified by 3/4 of state legislatures. Then the fourth approach is then the last alteration that's left. 2/3 of the states petition Congress for a national constitutional convention, and then any amendments that come out of that national constitutional convention are then ratified by 3/4 of state constitutional conventions. So you can kind of see why we've never used options 2, 3, and 4. Because options 2, 3, and 4 all have a constitutional provision to them, either a state constitutional convention or a national constitutional convention or a combination of the two. We are very afraid of a constitutional convention because we saw what happened the last time we had a constitutional convention. That last constitutional convention was called to try and amend the articles. We ended up throwing the articles out and replacing them with a completely different brand new constitution. There's concern that that could happen again. So to be on the safe side, I guess you'll say, we always use number 1. Proposal by 2/3 of the House and the Senate, and the ratification by 3/4 of state legislatures. Obviously, by giving states a role in either the ratification or the proposal of amendments, you are giving a nod to the anti-federalists. You're saying, anti-federalists, you have a role now to play. And as we talked about, when we talked about Federalist Paper number 39 last week, That's one of the arguments that Madison made, is that states will have a role to play in amending the Constitution. Article 6, assumption of debts in that first paragraph. Second paragraph is obviously the most important one. The Constitution, the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. This is your supremacy clause. This is a supremacy clause that the Federalists wanted to have very dearly in this Constitution. This is a supremacy clause that concerned anti-Federalists, and one of the reasons why anti-Federalists would not ratify the Constitution without the addition of the Bill of Rights, those first 10 amendments to the Constitution. Then Article 7 just talks about how the Constitution is ratified, and you have to have 9 states in order to ratify the Constitution. As we talked about last week, you got 10 states pretty quickly within the course of 2 years. You did not have the state of New York, and that's why you needed to then have the Bill of Rights. I think, as we also mentioned last week, the Bill of Rights was initially supposed to consist of 12 amendments instead of 10 amendments. The First Amendment was supposed to be what is now the 27th Amendment to the Constitution, limiting the ability of Congress to vary their compensation until they stand for re-election. And then the Second Amendment was supposed to be an amendment to limit the size of congressional districts to no more than 50,000 inhabitants. And I think we mentioned last week, if we would have limited our districts to 50,000 inhabitants, we would have 4,326 members of the House of Representatives today. So it's a good thing that we did not do that. But the amendments that did get ratified and make it into the Bill of Rights, these remaining 10 amendments, again, were done for the purpose of placating the concern and trying to mitigate the concerns of the anti-federalists. You're familiar with many of these amendments. Some of them we talk about all the time. Some of the amendments we don't talk about all that much, and they're a bit more obscure in nature. The first one you're very familiar with. The First Amendment talks about freedom of religion, freedom of the press, freedom of speech, and the right to peaceably assemble to petition government for redress of grievances. Even though we have these liberties that are spelled out in the First Amendment, we do know that there are some limitations that governments have applied and the judicial system has essentially sanctioned that do kind of limit some of these civil liberties for the purposes of the protection of public safety. So your first one, the freedom of religion. Freedom of religion, as you probably know from your civics classes, consists of 2 different parts. There's what's called the Establishment Clause and the Free Exercise Clause. The Establishment Clause says Congress shall make no law respecting establishment of religion. Congress cannot establish a religion. This basically means that you are free to believe any religion that you want to believe. So your freedom to believe in a religion is pretty much unfettered. However, when it comes to free exercise can be limited if it has an impact upon public safety. So if there's a religion that calls for the exercise of making killing animals and making sacrifices, that's something that can't be done in public because that has an impact, potential impact upon public safety. So you can't sacrifice animals in public. That's just one example of a limitation that can be placed upon the free exercise of religion. Congress may also not abridge freedom of speech. We know there are some limitations there as well. As the court said, yelling fire in a crowded theater is an exception to your freedom of speech because it places the public in harm's way. Freedom of the press, there can be some limitations on freedom of the press when it comes to national security. For the most part, we do not have what is known as prior restraint. Prior restraint, as we see in some other countries, is where the government can stop the publication of a story before it is published. There's not a whole lot of prior restraint in this country. We saw some attempts at prior restraint in the Nixon administration in terms of the Pentagon Papers and whether or not that information could be published. The Nixon administration tried to stop the publication of that information. But for the most part, the courts have a very dim view of prior restraint. even with petitioning to assemble to petition for redress of grievances, peaceably assembling can also have some limitations. And if you've ever organized a civil disobedience demonstration or something like that, you know that sometimes your city will require you to get a permit so that they know where you're going to be and they can then modify traffic patterns to try and keep people safe. So sometimes you do have to get a permit when you go out there to peaceably assemble. Second Amendment is one that we argue about a lot in this country, and we're not going to get into a value-based discussion about the Second Amendment. Everyone has their own position on it, and that's the nice thing about living in a country where we have a marketplace of ideas, because people can have their own interpretations. The Second Amendment says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This is one that Hamilton talked about frequently in the Federalist Papers and gave us a definition for what he meant by a well-regulated militia, down to the number of times that militia would have to meet every year in order to be considered armed and well-regulated. So it's always good if you want some insight into what the framers meant by the Second Amendment. The Federalist Papers do give us a little bit of that insight. Third Amendment is a pretty obscure one. No soldier shall in time of peace be quartered in any house without the consent of the owner. So here we're saying that you don't have to quarter soldiers. You have this right to privacy to your home. You can't be forced to put up soldiers in your home. That comes directly out of the Revolutionary War, obviously. The Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. This is what gives us search warrants. And so in order to search your stuff, you have to then have the police go to a judge and get a search warrant, unless the police believe that there is a good possibility that a crime is currently being committed. Clearly, if a crime is currently being committed, we want police officers to be able to enter that residence to make sure that that crime does not happen and to protect the safety of those inside. But other than that, you have to get a search warrant if you want to search someone's possessions. And now different states have state courts have certainly interpreted this a little bit differently. And this brings up a really important point with the Bill of Rights and your civil liberties. And that's this idea of incorporation, which we may have mentioned last week. We're going to talk a little bit more about tonight, and then we'll talk more about in the intergovernmental relations class. Incorporation is the process by which the courts have expanded these protections in the Bill of Rights that were protections against federal government action, have expanded those protections to include limitations against state government actions as well. Not all of these rights have been fully incorporated to include limits on state government action. Some of them have been fully incorporated, some have not. Depending on where you live, you will have different gun control laws, depending on the city you live in and the state that you live in. So gun control laws in California look different than gun control laws in Texas. And that's because the court has never fully incorporated these protections in the Second Amendment to include all state governments. And so that's why you have variation across states. In terms of unwarrantable search and seizure and the requirement to get a search warrant, this is one that has been pretty well incorporated across the states. And so this is something that is pretty common across all the states, regardless of what state you're in, because it has been more fully incorporated than the Second Amendment. Fifth Amendment provides for you some of your criminal justice types of protections, indictment by a grand jury, the ability to be protected from being tried for the same crime twice, otherwise known as double jeopardy, protection against being compelled to be a witness against yourself, protection against being deprived of life, liberty, or property without due process of law, protection against having your private property taken for public use without just compensation, which gets at the idea of eminent domain. The one to focus on here, though, with incorporation is that double jeopardy protection. The double jeopardy protection now has been incorporated to include limitations on state governments. However, that took a very long time for that to happen. And I don't think I mentioned it last week. If I did, I apologize. But in terms of double jeopardy, there is a very famous case in 1937 called Palko versus Connecticut. Palko, Palko versus Connecticut. In that case, Frederick Palko was tried by the state of Connecticut on murder charges. He was found guilty of second-degree murder. That wasn't good enough for the state of Connecticut. They wanted him to be found guilty of first-degree murder. So they went and they retried him. So they retried him again for the exact same crime he had already been tried for and found guilty of second-degree murder. In this second trial, they had obviously a different jury, and they were able to get him convicted of first-degree murder and then get the death penalty. Palko took his case all the way up to the Supreme Court, said that is a clear violation of double jeopardy. I was tried twice for the same crime. Supreme Court said, we are sorry, Mr. Palko. Double jeopardy protections in the Fifth Amendment only apply to protections against federal government action. So if the federal government was trying you, you would have double jeopardy protections. It does not cover the state of Connecticut. It wasn't until 1968, in a follow-up case called Benton versus Maryland, that the Supreme Court finally incorporated double jeopardy protections to include protection against state government action as well. So I mentioned that because it's a really great example of how incorporating these rights to include protections against state governments can be a very slow, protracted, and painful process. Sixth Amendment continues with some of your criminal justice protections. You have the right to a speedy and public trial by an impartial jury. You also have the right to be informed of the nature and the causes of the accusations you're being accused with. You have the ability to confront witnesses against you. And you also have the ability to have assistance of counsel. This ability to have assistance of counsel, this was incorporated fully through the court case Miranda versus Arizona. And this is why, for all of you who work in law enforcement, this is why you have to read someone their Miranda rights. It comes out of the case of Miranda versus Arizona, a more fully incorporation of the Sixth Amendment rights. Seventh Amendment provides you with the right to a jury trial in civil cases where the amount of the case is more than $20, kind of dates the Constitution. That $20 today is not what it was back in 1789. The Eighth Amendment, no excessive bail, no excessive fines, and no cruel or unusual punishment. This is where we discuss about the death penalty and whether or not states are able to use the death penalty and the different types of executions that they utilize. And whenever a state tries a new execution method, oftentimes there was an Eighth Amendment challenge to the use of that new execution method. We had a couple of Supreme Court cases, the Furman case and the Gregg versus Georgia case, both cases involving the state of Georgia. In the Furman case, we had the Supreme Court outlaw the use of the death penalty by states as a violation of the Eighth Amendment. In the Gregg case, we saw the Supreme Court reverse itself and then permit the use of death penalty at the state level. So today, some states have the death penalty, some do not have the death penalty, which really, again, does really focus our attention on the variation that we get in our system of American federalism. The Ninth Amendment, the enumeration of the Constitution, certain rights shall not be construed to deny or disparage others retained by the people. So all these rights we have enumerated to the government in the Constitution should not be construed as denying other rights that then belong to the people themselves. And then the 10th Amendment, the Reserve Powers Amendment, again, written for the anti-federalists. The powers not delegated to the United States by the Constitution nor prohibited to the states are reserved to the states respectively or to the people. So if a right is not given to the Congress in the Constitution, Article 1, Section 8, and it's not deprived to the states in Article 1, Section 10, then those powers then belong to state governments. And here is this tension we mentioned last week. You have the Supremacy Clause in Article 6 saying the national government is supreme in comparison to state governments. Then we also have in Article 1, Section 8, the Elastic Clause. Now here in the 10th Amendment, the Reserve Powers Amendment, we're saying that if it's a power that's not given to Congress, that power then belongs to state governments. Just underscoring how this Constitution is really very much a series of compromises. Then to quickly go through our remaining amendments, because I know we're getting very long in the tooth here in this first half of class, but the 11th Amendment limits the judicial power of the national government, especially in cases brought by citizens of one state against citizens of another state. The 12th Amendment was the creation of Thomas Jefferson, where he had his problems with Aaron Burr. As you know, if you've seen the Hamilton musical, that's really covered very in depth in the Hamilton musical. But Jefferson, at that time, the person who won the presidency became president. The person who came in second place became the vice president. Jefferson became the president. Aaron Burr became the vice president. They did not mix well. They hated each other. And so Jefferson, with this 12th Amendment, wanted to make sure that never again would a president be saddled with a vice president from another political party. Jefferson hated Burr so much that later in life, Aaron Burr was then almost tried for treason, and Jefferson wanted to try him for treason because Aaron Burr went out west, and Jefferson argued was putting together a military to then try and execute a coup of the Jefferson administration. Burr, to his dying breath, says he was not doing that, but that's what Jefferson believed. So they really didn't like each other very well. So we get the 12th Amendment out of that. 13th Amendment, as we know, outlaws slavery. The 14th Amendment is the one we're talking about a lot these days. And the 14th Amendment is known as the Equal Protection Amendment. In the Section 1 of the 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. This is your birthright citizenship. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of the law, nor deny to any person within its jurisdiction the equal protection of the laws. So this is why this has become known as the Equal Protection Amendment. This 14th Amendment really became it's always been important, but it became really publicized in the 2000 presidential election of Bush v. Gore. And if you're familiar with how that election went down, so to speak, we had a situation where it was a very close election. Al Gore won the popular vote, but the winner of Florida was undetermined for several weeks and really a couple of months afterwards. I was living in Florida at that time and teaching at a university in Florida. And so I kind of had a front row seat to what was going on in Florida. But we had this paper ballot system, obviously, because it was back in 2000. And you had interpretation of voter intent on those ballots. And so in order to vote in the state of Florida, when you get your ballot, you would then have your little hole punch, and you would then punch out the holes in the ballot. Sometimes those holes didn't get punched all the way out. Sometimes people didn't press hard enough, and so they were what we call dimpled chads. Sometimes they pressed hard enough so it would break through but not fall off. Those were called hanging chads. And so we had all these different counties in Florida doing their recount where they're holding these ballots up to the light to try and discern, did this person mean to vote for Gore or this person mean to vote for Bush? As that count went on, the difference in vote between Bush and Gore kept getting smaller and smaller and smaller. The Bush v. Gore case then went up to the Supreme Court, and the Supreme Court stopped the recount. And when they stopped the recount, it froze the count with soon-to-be President Bush having 527 votes more than former Vice President Al Gore. And let that sink in for a second. We're talking about the state of Florida. We're talking about millions upon millions of voters, and the difference at that time, 527 votes. The reason why the Supreme Court stopped the recount is because of the 14th Amendment, the equal protection. They argued that because one county was using one method to discern voter intent and another county was using a different method to discern voter intent, you didn't have equal protection for voters. If you lived in this county, your vote would have been counted. If you lived in this county, your vote would not have been counted. And so it violated this 14th Amendment equal protection, and that's then what stopped the vote recount, and that's then what led to the inauguration of President George W. Bush. So it became very important back then. We may see it again coming up in this ballot access case. It's very likely that there's an equal protection type of component there. that if you live in Colorado and you cannot have former President Trump on your ballot, but if you live in California, you can have him on your ballot. There may be some equal protection considerations there that the court will talk about. I don't know, but we'll have to wait and see. The one we really talk a lot about today is Section 3. You've heard a lot about Section 3, and Section 3 says no person shall be a senator or representative in Congress or elector of president or vice president or hold any office, civil or military, under the United States or under any state, who having previously taken an oath as a member of Congress or as an officer of the United States or as a member of a state legislature, goes on, shall be engaged in insurrection or rebellion against the same. So basically, if you have been elected to office, you served in office, and you have taken an oath, and that oath says to support the Constitution of the United States, and then you engage in an insurrection or rebellion, then you can be denied serving in office again. That disability of being denied to serve in office again can be removed by Congress with a 2/3 vote of the House and the Senate. The question here, obviously, is, can Colorado remove former President Trump from the Colorado ballot by arguing that he engaged in an insurrection? One of the arguments against it is obviously the Trump lawyers are saying that he did not engage in an insurrection, but then they're also saying that in the oath that we saw in Article 2 of the Constitution, it does not say support the Constitution. It says to defend and protect. It does not say to support. So therefore, technically, he never took an oath to support the Constitution. The third argument that they are making is that the president is not specifically mentioned here in Section 3. And if the framers wanted to include the president, they would have included the president specifically here in Section 3. They do mention specifically electors of president and vice president. They do say officers holding an office, but they don't specifically say the president. And so that's another argument that the attorneys are going to make to the Supreme Court, that you cannot exclude former President Trump from the ballot because as president, the president is not covered under Section 3 of the 14th Amendment. So again, interesting to hear what those oral arguments are once the live stream starts tomorrow morning. Okay, to finish this up, the 15th Amendment provides the right to vote and says the right to vote cannot be deprived based upon race, color, or previous condition of servitude. 16th Amendment provides for the federal direct income tax on individual incomes. The 17th Amendment provides for the popular election of U.S. senators. Under Article 1 of the Constitution, Section 3, senators were not popularly elected. They were selected by state legislatures. Here we're saying now senators are going to be elected by the people. The 18th Amendment is prohibition, outlaws liquor, the manufacture and sale of liquor. 19th Amendment is women's suffrage. The 20th Amendment changes the terms of the president and members of Congress, moving them up to January from March. Because if you have an election in November, then the person doesn't start serving until March. You have too much intervening time in between. 21st Amendment then repeals prohibition, repeals the 18th Amendment. 22nd Amendment gives us the 2-term limit for presidents, again, in response to FDR and the way in which he was elected to 4 terms as president. He died during his 4th term, but was elected to presidency 4 times. Now he can only serve 2 terms. The 23rd Amendment, which provides 3 electoral college votes to the District of Columbia. So that's the reason why we have 538 electoral college votes as opposed to 535. 24th Amendment makes poll taxes unconstitutional. Some southern states, as part of their Jim Crow laws, and as part of trying to reduce the enfranchisement of minority voters, what they would do is they would use these poll taxes to exclude people from voting. Those were then outlawed with the 24th Amendment. 25th Amendment sets up for us a possibility by which if the president becomes incapacitated, the vice president, along with either a majority of members of cabinet or the vice president, along with a majority of a committee that's established by Congress, can declare the president to be unable to carry out their duties. If the vice president is able to do that, then the vice president immediately takes over as president, assumes presidential duties, and then it's up to the president to then petition Congress whenever that president feels that they are able to resume their duties. They would petition Congress to then decide whether or not that person is then able to then resume their duties as president. The timing is not surprising that it was proposed in 1965 and ratified in 1967 on the heels of the assassination of John F. Kennedy. 26th Amendment then provides the right to vote to 18, 19, and 20-year-olds. And then the 27th Amendment, our final amendment, is one that was written by James Madison in 1789. It was finally ratified in 1992. No law varying the compensation for services of senators and representatives shall take effect until an election of representatives shall have intervened. So basically, members of Congress cannot enjoy the benefits of a pay raise until they first stand for re-election. Written by Madison way back in 1789, was intended to be the First Amendment to the Constitution, ended up becoming the 27th Amendment because it did not get ratified. It sat dormant for over 200 years. A student in Texas wrote a term paper saying that this was still a viable amendment because there was no what we call sunset provision. When we write amendments today and propose amendments, we will always put sunset provision saying that if this amendment is not ratified by 3/4 of state legislatures or state conventions within 7 years, it becomes null and void. Well, that was not a provision in this amendment when it was first written, so it was true that it was still a viable amendment. He wrote that term paper. I think he got a C- on it, but undeterred, went out there and started a national movement to get the remaining states to ratify the amendment. And lo and behold, on May 7th, 1992, he got the final state to ratify it, and it then became the 27th Amendment to the Constitution. We do not amend the Constitution very often. We've only amended it 27 times in our history, and 10 of those amendments came all at once in the Bill of Rights. And that 27th Amendment was supposed to be the First Amendment. So we don't do a lot of amending of the national Constitution. By contrast, we do a lot of amending of the California state constitution. The California state constitution, as we talked about last week, can be amended through either an initiative or a referendum process. And we have amended the California constitution well over 500 times in our history. So as we have 27 for the federal constitution, we have over 500 amendments to the state of California constitution. When we amend the state constitution, it looks different than when we amend the national constitution. We amend the national constitution, we append those amendments at the end of the constitution. In the California constitution, we change the language directly within the constitution. So you look at the California constitution, don't expect to see 500 amendments appended to the end of the constitution. We will literally change the language within the articles of the constitution to reflect those new constitutional amendments. I know this took us a long time to get through the Constitution, probably longer than any of us envisioned, but again, this is the only time you'll be able to do it. And so I think for any student in a public affairs program, it's important that you have this exposure to the Constitution because it really is that social contract between us as administrators and the citizens that we serve. So we need to know the Constitution. We need to know the rights and protections embodied within the Constitution, and then endeavor not to violate those rights and those protections. So I apologize for talking so much, but I hope that this was instructive. Again, we don't take a lot of time to sit down and look at the Constitution, but we took that time tonight, and probably the only time in the program that you'll have the chance to do that. Okay, we've been going at it for a while, and we're all very much overdue for a break. So let's go ahead and take our evening break. Let's take a break until 8 o'clock. And then when we come back at 8 o'clock, we'll shift gears and get into accountability and ethics. And we'll talk about how we can hold administrators accountable and why it is so important to hold our public administrators accountable for the actions they take on behalf of the public. So come back at 8 o'clock and we'll shift into accountability and ethics.
Recording in progress.
Okay, Welcome back, everyone. Hope you can hear me. I'm going to turn off my camera just in case. Having some problem with my earbud, but does everybody hear me okay? Yes?
Yes, we can hear you.
Okay, thank you. Thank you, sir. I appreciate that. Okay, let me go ahead and open up our slide deck then for our discussion of accountability and ethics. And again, I apologize I'm talking so much tonight, but there's just a lot of information for us to get through. And I do want to make sure that we get through this information on accountability and ethics, because this is information that you'll need for doing Canvas essay number 2. So I just want to make sure that we're able to get all that information to you so that you will be able to do Canvas essay 2. So when we talk about accountability and ethics, I think we all kind of have a good idea of what we mean by accountability. When we're talking about accountability, we are looking at the relationship between people and things in a very generic type of manner. So clearly in our context, the people that we are talking about is we are talking about administrators. The things we are talking about can be things such as the management of money, can be budgets, can be grant funds, can be organizations, can be the way in which we deal with our human resources, the way in which we deal with other organizations. And so we're looking at these relationships and how people interact and engage with other elements of their environment. Accountability is really the foundation of a bureaucracy, because accountability allows policymakers, elected officials, to hold administrators accountable for their actions. And when we think about, as administrators, we get our jobs, we get hired basically based upon our qualifications. And so we may take an examination, it may be a review of our knowledge, skills, and abilities on our resumes, but we get our positions based upon our qualifications. We are not elected into these positions. We therefore do not have a direct connection to the public. We are charged with executing the social contract, protecting these constitutional rights and liberties, but we are not held directly accountable by members of the public at the ballot box. Elected officials are. They are elected by the public. So in order for us to have this linkage between what we do and the public, in the middle there, we have our elected officials. And so elected officials are essentially the conduit. They're the connective tissue between administrators and the public. So it's important that we have the mechanisms in place so that these elected officials, these policymakers, are able to review and oversee the actions of administrators and then hold administrators accountable for their actions to make sure that administrators are operating truly within the public interest. The problem with enforcing accountability standards and ethical standards is that it always has this very negative connotation. When you think about accountability, we think about it being very negative because we think about discovering problems. So we held this person accountable for misuse of public funds. We held this person accountable for the harassment of another individual in the organization. We are holding people accountable and finding these problems that are going on within our organizations. As such, elected officials oftentimes do not want to exercise their oversight capabilities because it connects them with these problems. And they don't want to have this clear connection between themselves and these problems, because that clear connection could make it more difficult for them to get reelected in the future. When you think about a member of Congress, as David Mayhew told us 50 some years ago now, the primary motivation of a member of Congress is to get reelected. And one of the primary ways in which they get reelected is through engaging in a practice known as credit claiming. They want to claim credit, they want to be associated with positive things, things that their voters like. Well, clearly the voters are not going to like seeing an elected official necessarily connected with some type of ethical problem. The natural question would be, well, why didn't you stop it? Or why didn't you know about it before it became this big of a problem? So sometimes it's difficult for us to induce elected officials to get involved in the accountability process. But accountability is, again, imperative because what we need to do is we need to make sure that we have the ethical standards and the procedures and mechanisms in place to hold people accountable. But then we also need to afford them the flexibility they need to not just do their job, but to do their jobs well. Too many accountability mechanisms, too many ethical guidelines and ethical rules and regulations could inhibit the bold action on the part of administrators and could make administrators a little bit more reticent to do creative things and to do innovative things. And I truly hate the term thinking out of the box, but essentially that's what we're talking about. Doing things that are new and are innovative. And they will do those things if they're not concerned about being penalized for them. So we really need the balance between control and flexibility. So in the field of public administration, how have we dealt with this problem of accountability? Well, if you think about in the 1800s, we were squarely in this thing known as the era of patronage or the era of spoils. In a couple of weeks, when we get into the management of human resources, I will take you through the evolution, the development of the different eras of public employment from 1789 up until the current point in time. In the 1800s, we were in this thing called the era of spoils. In the era of spoils, our administrators got their positions based upon which political party they supported and whether or not they supported the winning candidate. So the era of spoils, political parties would dole out jobs as rewards for helping that elected official, helping that political party ascend to power. So in this era of spoils, most of our large cities at the time were controlled by political machines. So New York City, Boston, Chicago were controlled by these political machines that controlled pretty much every aspect of governance within that city, and certainly controlled the bureaucracy in that city as well. One of the most famous political machines was a political machine that operated in New York City called Tammany Hall. And you may have heard about Tammany Hall before. There have been a lot of TV shows on Tammany Hall. I believe that there's a Gangs of New York show that covers Tammany Hall. So it's a very famous political machine. One of the members of Tammany Hall, one of the members of that political machine, was a man by the name of George Washington Plunkett. And George Washington Plunkett wrote his memoirs. It really gave us some really interesting insight into how that political machine operated. And in his memoirs, he described the situation where he said that there was something called honest graft and something called dishonest graft. Now, in public administration, when you think of the word graft, we think of it as being equivalent to corruption. So you can use those terms interchangeably. So essentially, he was saying there's an honest type of corruption and there's a dishonest type of corruption. So the dishonest type of corruption would be if you just, put your hands in the coffer and take city money out of the coffer. That's dishonest graft. He felt himself above that. But he said there's a category of corruption he considered to be honest corruption. And one example he provides for us for honest corruption in his memoirs was, he said, assume that in my position in local government in New York, that I find out that the city is going to build this new city park. And in order to build this city park, the city has to buy this plot of land. So he finds this out. It's non-public information. He found this information out by virtue of his public position, his position in the bureaucracy. He takes that information, he goes out there, he buys the plot of land at a very cheap cost because nobody else knows this land's going to be used for anything. So he gets it for a song. He then turns around and sells it to the city and makes a handsome profit. He says, that's honest graft. That's honest corruption. As he says in his memoirs, I seen my opportunities and I took them. Now, today, we would consider that to be corruption. We would consider that to be dishonest because he was using information as part of his public position for private gain. He was, in essence, putting private interests above public interests. And today, I think we would all agree that was corrupt. But in this era of political machines, this era of spoils and patronage, that was commonplace. We didn't really have mechanisms for controlling the actions of individuals. We didn't have methods for making sure that we had ethical adherence. In 1881, there was this big triggering event in policy that was known as the assassination of President Garfield. And we'll get more into the assassination of Garfield when we talk about the different eras of public employment. But essentially, a disgruntled office seeker who had written some campaign speeches for then candidate James Garfield believed that once Garfield was elected president, Garfield, since it was the era of spoils, owed him a position. Garfield didn't even know who this person was, had never used any of those speeches, and therefore did not award a position, a national position to this person. This person then went and assassinated Garfield. That really galvanized public opinion around the idea that the era of spoils wasn't working. In the era of spoils, we had way too much graft, we had way too much corruption, we had way too much incompetence. And so we needed to change the way in which we hired people to work in the federal bureaucracy. And we also needed to change the way in which we monitored their behavior and hold them ethically accountable. So in 1883, we get this piece of legislation called the Pendleton Act, which was sponsored by a representative from New York called by the name of George Pendleton. And the Pendleton Act created our current system of merit, whereby we would select people to work in government not based upon their party affiliation, not based upon how much money they gave to a candidate or how much they supported a candidate, but rather we'll select them based upon their competence, based upon their merit, based upon their knowledge, skills, and abilities. Once we end up getting this era of merit that comes in 1883, scholars started to take note of this era of merit. And one of those scholars was Woodrow Wilson. And that's the same Woodrow Wilson that eventually became president of Princeton University and would then ascend to the presidency himself. Now, you will read Woodrow Wilson's The Study of Administration in a couple of weeks, and we'll spend a lot of time dissecting it and talking about it. Because in Wilson's The Study of Administration article, he establishes the basic framework for the discipline of public administration. He establishes the rationale for why we need to study administration differently than how we study politics. In Wilson's article, he sets up this thing that you have probably heard about before called the politics administration dichotomy. And the argument that Wilson makes is that the world of the 1880s was a very complex world, and that the work of administration had become very, very complicated. So much so that that complexity required a separate field of study. So he said, if we study administration separately from politics, what we can do is we can make sure that that administration, what he called the business of government, was being done more efficiently and more effectively. So what the politics administration dichotomy advocates for is on the administrative side, we have administrators who carry out the laws that are passed by the elected officials on the political side. So it delineates for us the proper roles of an administrator versus the proper roles that should be left to an elected official. So in the context of ethics, if we see an administrator who is going beyond just a benign administration of a law, and we see an administrator who is playing on the political side of the equation, we can term that behavior to be unethical because it goes beyond the administrative duties of that administrator. So by having this bright line distinction between the political world and the administrative world, it makes it easier for us to identify unethical behavior and then hopefully limit that unethical behavior. So it's kind of a very black and white, very either or type of an approach in this politics administration dichotomy. Very early on, though, within a few decades, scholars realized that this politics administration dichotomy was kind of a false premise, in that we realized that the political world and the administrative world oftentimes overlap with each other. When you think about these laws that are being passed by Congress or being passed by state legislatures, Typically, these laws are very vague and very ambiguous. They have to be vague and ambiguous in order to get through these legislative bodies. If you want to get a majority of 435 members of the House of Representatives to agree to any law, you can't put a whole lot of specifics into it. The more specifics you put into a law, the more likely you are to engender controversy and get opponents coming out of the woodwork to oppose that piece of legislation. So the laws that come out are very vague and ambiguous, and there's not really a lot of direction in how they should be implemented. So, as John Gauss points out in 1936, because of this overlap between politics and administration, sometimes some of the political roles end up getting played by administrators. So, administrators need to determine the rules that will govern the implementation of this legislation. It's the administrative rulemaking process. That administrative rulemaking process is essentially policy formulation. Well, under Wilson's dichotomy, policy formulation was the sole domain of elected officials in the political world, and it shouldn't be going on in the administrative world. Here, Gauss is saying, but it does go on in the administrative world. So, because of this overlapping between politics and administration, it becomes much more difficult for us to say, well, if an administrator is engaging in policy formulation, they are engaging in unethical behavior because it's something that they have to do in order to execute these policies and these laws. So we saw the politics, administration, economy really fall into a lot of disfavor throughout the 1900s. And we'll talk again in a couple of weeks about why we really don't have this clear politics, administration dichotomy today. Well, the current approach to accountability in public administration is a recognition that public administration has become far more complex than it certainly was back in 1887 when Wilson wrote his article. Today, the administrative world is so complex that it's difficult for us to have a hierarchical chain of command when it comes to ethics. It's impossible for us to have a single professional norm or a single professional expectation for every single agency throughout the entire bureaucracy. Today, we have really come to embrace organization theory known as organization culture, where we accept that every organization has its own unique culture, its own unique set of norms and expectations and values. Since every organization has its own unique set of expectations, norms, and values, it's difficult from us from the top level to come down and say, this is how you need to do things, or this is ethical, this is not ethical. Instead, we have seen organizations develop their own code of conduct and code of ethics that their employees will then adhere to. So, what I like about our current approach to accountability is that it really is very much in line with my favorite answer to everything, which is it depends. It depends upon the context of the situation. It depends upon the agency. It depends upon the norms, the values, and the expectations of those agencies. Now, clearly, there are some expectations that we all adhere to. We all adhere to the expectation that we will work in the public interest as opposed to the private interest. We all work under the expectation that our work is done in the open, it's done in the public, and that we should facilitate public exposure to the decisions we make and the way in which we manage our resources. So, those are some clear maxims that I think everyone in public administration agrees to. But we recognize that each individual organization will have its own code of ethics, and those codes of ethics may differ between those organizations. So today, accountability tends to be a little bit more contextual than it certainly was back with Woodrow Wilson and his clear distinction between the political world and the administrative world. So today, when we take this contextual approach to accountability, there are different things that we hold people accountable for. There's what's known as fiscal accountability. In fiscal accountability, we are concerned with how agency officials, how administrators are spending money. Are they spending public money on the programs that they are charged with managing? So, are they spending the money in the legally appropriate manner in which they are supposed to spend that money? In the public sector, we have a lot of required audits. Two different types of audits that we tend to do in the public sector. The first type of audit is what's known as a legal or financial audit. In a legal or financial audit, we're asking that question, are we spending the money in the legally mandated way in which that money is supposed to be spent? If not, if we are misappropriating funds, if we're spending funds on things that are not sanctioned by law, that is unethical behavior, and we need to be held accountable for that unethical behavior. And we can see that with these legal financial audits, especially when these audits are conducted by external companies, by external auditors. The second type of audit that we do is we do performance audits, or sometimes they're called management audits. In performance management audits, we're not just asking how the money is being spent, like we do in a legal or financial audit, but in a performance or management audit, we're asking the question, how well is the money being spent? So how are we spending the money, and how well are we spending that money? That gets us into a second approach to accountability, which is called process accountability. In process accountability, we are concerned with how agencies are performing their tasks on a daily basis. So here we're looking at policy and program implementation. So looking at how agencies and how administrators are implementing these policies and these programs on a daily basis. So here we're looking at process implementation and holding people accountable for spending money in the most efficient way possible in implementing these programs, these policies. So this is where we're getting at things such as waste and wasteful spending. Then the third type of accountability is program accountability. Here we're concerned with the outcomes of that program or that policy. We're asking the question, does this public program achieve its purposes as defined by law? Or how well is this program achieving its goals and its objectives? And that we call program accountability. Those management and performance-based audits can help us get at those questions of process accountability as well as program accountability. Legal financial audits get us at fiscal accountability, making sure we're spending the money in the legally appropriate way in which we are supposed to spend that money. So it's important to note that accountability is multidimensional. Just like our discussion last week of power as a multidimensional concept, accountability is a multidimensional concept as well. And we have to know what we are holding people accountable for, how they spend the money they're spending, how they're spending it, or how well they're spending it in terms of how they're implementing the programs and the goals and objectives that are being achieved by those programs. However, in holding administrators accountable, we have a problem that we encounter. And the problem that we encounter is a problem known as the principal-agent relationship. And you may have run into this principal-agent relationship before in some of your other courses at the undergraduate level. But in a principal-agent relationship, we have this relationship between a principal and an agent. The principal in the relationship is the one that has the power, that has the ability to hold the agent accountable for their actions. They are the overseers of the agent. So in this relationship, Congress would be the principal, a federal agency would be the agent, or at the state level, the state legislature would be a principal, or the governor would be a principal, and the state agency or the local agency would be the agent. Now, for the principal-agent relationship to work, the principal, in order to carry out their oversight responsibilities, they will need to have the information necessary to know what the agent is doing. If they don't know what the agent's doing on a daily basis, it will be impossible to hold that agent accountable. So in a normal situation, you would think the principal has more information than the agent. However, we know in the principal-agent relationship, there's a lot of information asymmetry. And that information asymmetry exists when the agent actually has more power and more knowledge than the principal. So when you think about public agencies and what they do on a daily basis, a lot of what agencies do on a daily basis are a lot of that's shielded, not only from the public, but also shielded from elected officials. So who knows what's going on the ground on a daily basis than members of that agency. So really the agent has the information. And when you have that type of information asymmetry, oversight becomes very, very difficult. So in that situation where the agent has the information, has the resources, it then becomes kind of a quandary for that agent when they have to decide what information and how much information they need to give up to the principal. If Congress doesn't know the right questions to ask, they're not going to ask the right questions to hold an agency accountable. So they need to have the information to know what questions to ask. That information comes from the agent. That introduces what's known as a moral hazard. And so the moral hazard here for the agent is if I provide this information to the principal that will assist the principal in holding me accountable, I will then be subject to a lot more scrutiny. And my life is probably going to become a lot more difficult than if the principal didn't have that information to start with. So there's a disincentive for agents to provide the information that the principal needs to conduct oversight. That's the moral hazard. However, for the principal agent relationship to work, agencies must fully inform and advise the principals so the oversight process is able to be conducted. When we talk about the ASPA Code of Conduct, fully inform and advise is one of the 8 principles under the ASPA Code of Conduct. So where does this information then come from out of the agency? We need to empower members of the agency to point out ethical violations. We need to empower members of the agency to essentially be the voice of ethics so that they can point out these ethical violations, they can point out violations of civil service protections, and they can do that without fear of punitive measures, without fear of reprisal. The voice of the organization, these individuals who bring forth these problems and shine light on these problems, those are your whistleblowers. And you're all familiar with the term whistleblower. Those are the people who are blowing the whistle on the ethical violation. We need to protect those whistleblowers so that they feel comfortable bringing this information to light. In 1989, we had a big piece of federal legislation known as the Whistleblowers Protection Act. And in the Whistleblowers Protection Act, we made it illegal to have reprisals against or retribution against whistleblowers in an agency. So we protected them from any negative, punitive types of measures as a result of them blowing the whistle. We had 2 organizations at the federal level, the Merit Systems Protection Board and the Office of Special Counsel. The Merit System Protection Board would receive a complaint from a whistleblower. The Office of Special Counsel would then investigate that complaint to make sure that there were no reprisals that were being placed upon that whistleblower. So we've now in federal law have these protections for these whistleblowers, because if we don't protect the voices of the organization, these whistleblowers, then they're just going to exit the organization. They're just going to leave the organization, go elsewhere, and we'll never know about those ethical violations that were occurring within that agency. So it's vital that we protect these whistleblowers if we want to hold agencies and actors accountable for their actions. So as you might guess, the ethical standards in the public sector oftentimes seem to be a little bit higher, if not a lot higher, than what we see in the private sector. And one of the reasons for these differential ethical standards has to do with the values that underpin the public sector versus the values that underpin the private sector. So you're running a private corporation, you have a private firm. What are you trying to achieve? What are you trying to accomplish as the head of this private firm? What's probably your number one goal? Making money, exactly. As Renee said, making money. You've got a bottom line. That bottom line is you need to run a profit. If you do not run a profit, then you're going to be out of business very, very quickly. In order to make money, in order to run a profit, there are 2 values that become very important to you. One value is efficiency. The better you can use less resources to create more output, the better chance you have at maintaining your bottom line, at running a profit. So efficiency becomes very, very important to the private sector. The resources that they are using in the creation of their good or service, those resources are going to come from the profits that they are generating. So that means they need to produce a product that will compete with the products being produced by other similar corporations. You've got a lot of competition in the private sector. So that makes effectiveness another very important value. So you need to create a product that people will like, that will meet the wants, needs, and desires of your consumers. You need to create an effective product, but you also need to be very efficient in the way in which you're utilizing your resources. So efficiency and effectiveness really kind of rise to the top in terms of the values that are of the utmost importance in the private sector. Now, that's not to say that efficiency and effectiveness are not important in the public sector. After all, you have an entire course in this program, the research methods course, that is oriented around program evaluation and learning ways in which we can evaluate the effectiveness of programs from an empirical perspective. So we wouldn't devote an entire class to program evaluation if it wasn't important. So effectiveness is important for us in the public sector. And efficiency is important as well. But efficiency and effectiveness work a little bit differently in the public compared to the private sector. In the private sector, revenue resources are coming from profits. So profits are based upon sales. Sales can be very transient. Sales can be very temporary, and they can fluctuate depending upon a lot of different things. They can fluctuate based upon the entry of new corporations into the competition in your environment. They can fluctuate based upon macroeconomic cycles. And so if people are out of work, we have high unemployment rates, people have less disposable income, they're less likely to purchase your goods. They can vary based upon regulations. You might get hit with certain regulations that then makes it more expensive to produce your good, which means you then have to raise the price of your good, which means that if it's a very what we call price elastic good, then demand for that good will drop, and then your profits are going to go down as well. So it's kind of unpredictable when your revenue is coming from profits. Contrast that to the public sector. In the public sector, a lot of our public agencies get the lion's share of their money from appropriations that are legal, that are made by legislative organizations. Appropriations tend to be much more static and much more stable than money you're getting from profits. We'll talk later on in this class about incrementalism as a decision-making type of model. Incrementalism really does characterize the appropriations process in that every year agencies tend to get basically what they got last year with maybe a little bit of an increase to cover cost of living adjustments. So they're very stable. And if you're a stable revenue stream and you have that stable revenue stream, then you're probably not as concerned about being efficient as if you have an unstable revenue stream like in the private sector. Effectiveness is important, as we said, in the public sector, but we also recognize that we oftentimes have less competition for our goods and services in the public compared to the private sector. When there is less competition, then effectiveness is always important, but it may not be the top value that you have as you would have over in the private sector. So I think you can certainly say efficiency and effectiveness are important for the public sector, but we also have to balance efficiency and effectiveness with a lot of other values that underpin public administration. So some examples of those additional values are things such as social equity. And we'll see social equity very prominently when we look at those 8 principles in the ASPA Code of Ethics. But social equity really rose to prominence in public administration with the work of a scholar named H. George Frederickson and what he termed the new public administration. And in the new public administration, social equity now becomes a very important value that we adhere to in public administration. In that Bennington and Moore article in the Classics text, they talk a lot about public managers needing to add public value, that whenever public managers are managing a program with public funds, those public funds are displacing what would normally be used up with private funds. We're displacing private resources with public resources. As such, the value that we're creating needs to be pretty profound in nature. So instead of just creating an effective product, we also need to add value by adhering to these social equity principles as well. We also adhere to values and principles such as the protection of individual rights. So we talked about this a lot last week in terms of the Constitution. The Constitution lays out these individual rights. We need to know those rights and then endeavor not to violate those rights. We protect individual rights in the public sector. In addition to the protection of individual rights, some other values that we have are things such as a representative bureaucracy. So we try and create a representative bureaucracy so that the bureaucracy reflects the population that bureaucracy is serving. In addition to representative bureaucracy, we have other values such as political responsiveness. And this is not a universal comprehensive list, but just some of the major values in the public sector. We have to be politically responsive, as we talked about the principal agent relationship, and provide information to our overseers, to members of Congress, and to the executive branch in the oversight process. The more politically responsive we are, the more likely we are to have the support of those elected officials, which is very important when it comes time for appropriations and making budgets. So the point here is not to belabor it too much, but the point here is that when you have all of these additional values in the public sector, these values can really come into sometimes conflict with each other. So if you want to be as efficient as possible, sometimes when you're protecting individual rights, it kind of slows down your efficiency, which is a good thing. That's a good thing because you're protecting individual rights. But it makes you a little bit less efficient, perhaps, as an organization from a purely economic type of perspective. Same type of thing with political responsiveness and social equity and representative bureaucracy. So we are balancing a lot more values in the public sector. When you have all these additional values that you are balancing, your ethical standards tend to increase as well, because you need to make sure that people are adhering to all these different values beyond just being efficient and being effective in their jobs. So we oftentimes make the argument that public sector ethic levels are higher than those in the private sector. And so sometimes when people make that lateral entry from the private sector into the public sector, they are met with this shock of ethical upgrade. And sometimes it does make it difficult for us to attract people from the private into the public sector. If you are going into the public sector, you're probably going to get paid less than what you're getting paid in the private sector. You may have better benefits, but you're getting paid less than what you're getting paid by your private corporation. And you're being held to higher ethical standards. You have a lot more accountability mechanisms, more audit requirements. Not to put it, in too basic terms, but it really does become more of a hassle on a day-to-day basis for less money, if that makes any sense. And so that's what makes it difficult for us to sometimes attract people into the public sector. That's why we really need to do a good job of balancing these accountability mechanisms with still providing the freedom and flexibility for people to make their own decisions and to be creative and innovative when they're doing their jobs. If we are successful at finding that balance between accountability standards and creativity and flexibility, that's where we create a truly quality public service. And at times in our history, we have had some leaders that have really been champions of the public service. You think about somebody like George H.W. Bush when he was president. He was a lifelong public servant. And so he referred to government service as being the highest and the noblest calling. Barack Obama, in his first run for the White House in 2008, said that one of the goals of his administration was to try and make government and public service cool again. Now, I don't know if President Obama succeeded in making public service cool again, but it's just an example of how some elected officials have really kind of been champions of the public service, recognizing that public administration is complicated and that we need to make it attractive so that we can attract the best and the brightest into public service in order to make it a fulfilling vocation. So that's more than just a job, it's a fulfilling vocation that helps to further the public interest. Hopefully what we are able to do is we are able to get people into the public service who have this thing we call in public administration, the public service ethos, that they believe in benefiting the public and they're there to try and put public interest above private interest, which is another one of those principles in the ASPA Code of Conduct that we are going to talk about right now. So you see on this next slide, I provided for you the 8 principles in the ASPA Code of Conduct. This is what you're going to be using for both the breakout groups that we're going to do. We might not do them tonight if we run out of time, but we'll certainly start our class next week with those breakout groups. You'll use these in your discussions in your breakout groups. And you'll also use these 8 principles in your Canvas essay number 2. And they'll also come into play as well on your midterm assessment. And that hasn't been published yet, so it's not on Canvas as of now, but I will publish it next week. So you'll have a full 2 weeks to work on it. But there is a question on there that deals with the ASPA Code of Conduct. I know that we're covering it many times in this class, but I think that is important because this is the one code of conduct that we all share as public administrators. When you think about the backgrounds that people come into public administration with, we have engineers. And in this distance learning program many years ago, we had a work site at the Orange County Transit Authority, OCTA. And the vast majority of those students were engineers with OCTA. And we still have a good number of engineers in our MPA program. Engineers have their own professional organization. They have their own professional code of conduct. Some public administrators are budget analysts. They have their own organization, their own codes of conduct. Some people are HR professionals. They have their own codes of conduct from their own professional organizations. So those may all differ from each other depending upon your profession, but as professional public administrators, we are all under the American Society for Public Administration Code of Conduct and these 8 different principles. The first principle is public interest, to operate in the public interest, to promote the interests of the public and put service to the public above service to oneself. This is an example of a principle that clearly was being violated by George Washington Plunkett in his memoirs. When he's purchasing land at a reduced cost and selling back to the city at a higher cost, he was doing it for his private interest. It certainly wasn't for the public interest because it ended up costing the city of New York more money to purchase that land from him than if it had been just left on the market. Second principle, uphold the Constitution and the law. This is why we spend an hour and a half or more than that tonight going through the Constitution. Respect and support government constitutions and laws who are seeking to improve laws and policies to promote the public good. It is imperative that we know what the constitutional rights are of our citizens, and as I've said many times, then try not to violate those constitutional rights. The third principle is to promote democratic participation, to inform the public and encourage active engagement in governance, to be open, transparent, and responsive, and respect and assist all persons in their dealings with public organizations. This is why we have things in California such as the Brown Act and the Green Act and all these sunshine provisions so that the public can see governmental decision making and have access to it and ability to participate in that governmental decision making. Now, promoting democratic participation certainly can have a direct impact upon your efficiency as an organization. You're going to be less efficient the more stakeholders that are involved in the decision-making process. But we need to promote democratic participation. And we'll talk in a couple seconds about some of those things we do here in California to adhere to principle number 3. I told you social equity is now one of the primary principles in public administration, and that's underscored by number 4, strengthen social equity, treat all persons with fairness, justice, and equality, and respect individual differences, rights, and freedoms. Promote affirmative action as a law and other initiatives to reduce unfairness, injustice, and inequality in society. Strengthening and promoting social equity is that 4th principle in the Code of Conduct. 5th principle we've talked about before in the principal-agent relationship, fully inform and advise. Provide accurate, honest, comprehensive, and timely information and advice to elected and appointed officials and governing board members and to staff members in your organization. This is overcoming that moral hazard, providing the information that will lead to more scrutiny of us as administrators, but will help the principal-agent relationship operate more in line with accountability. Number 6, demonstrate personal integrity, adhere to the highest standards of conduct to inspire public confidence and trust in public service. I think it's probably not a debatable fact that trust in government has certainly been on the decline in recent years. There's a lot of distrust in government. There's a lot of distrust in public agencies and administration. Demonstrating personal integrity is just one way in which we can role model to try and increase the trust in public service. Number 7, promote ethical organizations. Strive to attain the highest standards of ethics, stewardship, and public service in organizations that serve the public. When you take your 660 organization theory class, which you will have with me, we will talk a bit about creating more ethical organizations. One of the case studies that we have used in 697 for org theory over recent years focuses on a case study in which an organization engaged in some unethical conduct, and then you will be offering strategies to help that agency become more of an ethical organization. Number 8 is to advance professional excellence, to strengthen personal capabilities to act competently and ethically, and encourage the professional development of others. Sometimes it's the last part of number 8 that becomes difficult, encouraging the professional development of others. For years, we have heard about this retirement bubble in the public sector, that we have this bubble of primarily baby boomers who are nearing retirement age, and eventually that bubble will burst. They're all going to retire en masse, and when they retire, then we're going to have younger employees move into those leadership and management positions. In order to move into those leadership and management positions, they need to have the requisite skills in order to successfully carry out those positions. So we need to encourage that professional development so that we can put those succession plans in place. So when the time does come for leadership to leave, we have new leaders who are able to step into those positions. We've heard a lot about this retirement bubble. I don't think it's really has even burst yet. We still have a lot of people from baby boomer generation who are still in these leadership positions. We heard about what was called the Great Resignation, and we thought after COVID-19 that all those folks would then say, well, I'm done. I'm not dealing with remote work. I'm not dealing with any of these things that came as of COVID-19. I'm just going to leave and retire. Some did, some resigned, some retired. But I think we still have a good bit of that retirement bubble that we still have to work through. And that's why number 8 is so important for succession planning. So those are your 8 principles in the ASPA Code of Conduct. The thing I'm going to ask you to do in your Canvas essay number 2 is, after reviewing those 8, to identify 3 of those that you think might be the most difficult to implement. And I want to be very sensitive to the fact that if you're working in an organization that you don't want to talk about your organization in relationship to ethics, I completely understand that. And I support you not doing that if you don't feel comfortable doing it. So you can approach this Canvas essay from a much more macro level, generic type of perspective, where you can talk about, which 3 of these you think personally would be most difficult for you to engage in, and or from kind of a more generic public organization perspective, which 3 do you think would be most difficult for a generic public organization to adhere to? So you don't have to use your own organization if you are not comfortable using your own organization. But this forms the basis then for Canvas essay number 2. Let's look a little bit more, let's a little bit more closely then at number 5, this fully inform and advise, as well as number 3, promoting democratic participation. In order to accomplish both of those, we need to engage in as much transparency as we possibly can. And the more transparent we are, the more we open the doors up and do what we call let the sun shine in, the more likely we will be able to hold people accountable for their behavior and adhere to these ethical standards and these principles in the ASPA Code of Conduct. We live in a state here in California that is very much of a sunshine type of state, in that we have a lot of these transparency laws on the books that require public organizations, public agencies to allow the public to see what's going on, as well as to participate in decision-making processes. The one that you're probably familiar with, the Brown Act, not named after the governor, Jerry Brown, it predated him, but the Brown Act, which requires that public meetings that are held between a majority of members of that city council or members of that board, that those meetings must be done in the public. So if you have 5 members of your city council, 3 of them are going to discuss an item of relevance to that jurisdiction, then that discussion cannot happen via email. It cannot happen over the phone or text chat. That must happen in an open session, open to the public, that has been agendized. So those issues that you're going to talk about in open session in that public meeting must be listed on an agenda. That agenda under the Brown Act must be publicized at least 72 hours in advance of that regular meeting. Now, if there's an emergency, a special meeting, then it's not 72 hours, it goes down to 24 hours. But for a regular public meeting, you have to agendize the meeting at least 72 hours in advance. You have to adhere to those issues, those topics that are on the agenda. In those public meetings, you also have to allow public participation. So there needs to be a period of time allowed for public comment. And if ever you work with city councils, you've seen this. The city council will set aside time for public comment, oftentimes public comment on agendized topics, and then another section of public comment for non-agendized topics. And the city council can limit the amount of time because, after all, the city council has work to do. So it can't just sit there for 6 hours and just listen to the public. So the Brown Act allows for reasonable limitations on public participation. So, when I served on the board, we had a 20-minute limit per topic for public comment. And then we normally limited each public comment, each individual, to 3 minutes for their public comment. That's a judicially vetted approach that was considered to be a reasonable way in which you can limit public comment, but still allow the public to participate. There is a provision in the Brown Act for closed sessions or confidential sessions. Closed sessions are only for a limited number of items. So you can go into closed session outside of public review and purview if you are doing things such as talking about an employee and discipline of an employee. Those types of personnel issues for privacy reasons can be done in closed session outside of the eyes of the public. If you have existing or pending litigation and you want to have a conversation with your legal counsel, that can be done in closed session as well. Back when I was on the school board, we went through some major modifications to our schools for public safety and to kind of harden our school infrastructure against school shootings and things such as that. A lot of those discussions with the sheriff's department, with risk management firms, a lot of that was allowed to happen in closed session because you don't want to, in open session, talk about some of the vulnerabilities that your school buildings might have so that anyone in the public can hear that and then try and exploit that type of information. So the Brown Act really does require that we do our work out in the open so the public can see what we are doing. And there are a lot of other parts of the Brown Act, but this isn't a Brown Act seminar, so we're not going to get into all those different provisions. Another good example of transparency here in the state of California is our public records request law. So any member of the public can request public records on any issue or topic that they want to request public records on. They can submit that public records request with a simple email, so they don't have to fill out a form. You're allowed to do it via email. So they can just email the city and say, I want to see all the correspondence that went on in terms of the awarding of this contract, because I don't think this contract was awarded in the way in which it was supposed to be awarded under a public contract code. And so then that city council and the city staff would then have to go through all their communications and all the documentation they have about that contract being awarded and then release that information to the requester within 10 days. Now, you can get an extension on that 10-day period if putting that information together is overly onerous and will cost way too much time and resources. You can ask for and get an extension past that 10 days, but technically you have 10 days to be responsive to that public records request. There is a court case here in California called the San Jose case. It's just kind of commonly referred to as the San Jose case, that says that you have to produce all communication. So we're not just talking about emails, we're not just talking about printed documents. We're talking about if you have any text messages on a personal phone that it would be responsive to this request. Those text messages must then be provided to the requester. Even if it's your personal cell phone, it still needs to be provided. And so what a lot of governments will do is they will ask their administrators, they'll ask their elected officials, go through your phone And if you have anything that is responsive to this request, you need to provide it to us within 10 days. If you don't have anything responsive to this request, you need to sign this affidavit attesting to the fact that you don't have anything on your personal cell phone that is responsive to this request. Obviously, if you sign that affidavit and then later on it's found out you have information that should have been disclosed, you're going to be in a lot of trouble. So we have a very strict public records request law. We also try and control for conflict of interest here in California as well. So for people who are in reportable positions, you may or may not be in a reportable position. All elected officials are. A lot of top level administrators are as well. Here in the Cal State system, what we call the MPPs. MPPs are administrators such as provosts, vice presidents, deans, associate deans. Those are all considered to be reportable positions. If you're in a reportable position, you need to fill out this conflict of interest form known as Form 700. On that form, you have to then disclose anything that could be a conflict of interest with any issue that comes before your board or your city council. And so if you own any rental properties, within the jurisdiction, you have to report the value of those rental properties and any type of rent that you are getting from those rental properties. You don't have to report your primary residence, that's exempt, but any other residence has to be reported if it's within that jurisdiction. If you are receiving any payments or any income from any employers or any other sources within your jurisdiction, you will have to report those sources of income as well, so that we have written documentation of any potential conflicts of interest, so that if an issue comes before the city council that could pose a potential conflict of interest, we know it. And we know as the public, this is a potential conflict of interest. So we can then demand that that member of city council recuse themselves from that discussion on that issue. Again, this is not the universe of all the things we do in California, but just an example of how we try and maintain ethical adherence through all these transparency types of measures. But to kind of wrap all this up, we've talked about over the past hour, in order to achieving accountability is all about striking that proper balance. And there are two types of balances, if you will, we need to strike. One balance we need to strike is the balance between external laws and rules and regulations and the training and character of our individual administrators. You can have all of the external rules and regulations that you want to have in terms of ethics, but if you have public administrators who do not have that public service ethos, who are not putting public interests above private interests, they will oftentimes ignore those ethical standards, and they're going to do what they're going to do anyway. So you need to have both the right set of external rules, and you have to have the training and character of your individual employees so that they do really value public service. And so you need that as one of your points of balance. But secondly, you also need to try and balance your accountability mechanisms with the ability for employees to be creative and innovative. You certainly do not want to depress their ability of making difficult decisions because they're afraid of running afoul of some rule or some regulation or some law. So it's important that we balance ethical adherence with effectiveness. If we do that, that will help us better meet the needs of the public and public demands, but it will also help us better attract people into the public service. If we are not attracting qualified individuals who are really bought into this idea of making the public a better place, we're not going to be able to have ethical administration. Now, this is just a very brief introduction and overview of ethics and accountability in the public sector. As you move throughout the program in future classes, you will again return to this idea of ethics and accountability. You'll get it in the budgeting course with Dr. Zhao. You'll get it in the HR course with Dr. Martin. You'll get it with me in organization theory. You'll get it in policy with Dr. Matthews. You'll get it in research program evaluation with Dr. Butts. And then you'll also get it in some of your elective courses as well. You have one elective course in the program, PPA 512, which is Urban Executive Management with Professor Armijo. he teaches that very much from a case study type of perspective. And some of the cases that he talks about in urban executive management are cases that deal with ethical violations and kind of putting you in the position of, if you were in this position, how would you respond? And then, well, this is how the administrator actually did respond. And so you get a lot of that in your 512 class. You get some of it certainly in terms of social equity in your 610 urban affairs class. That's a very big topic in there. When you do 570 negotiating dynamics, you will talk about bargaining negotiations and how to bargain in an ethical manner from a good faith bargaining position. So, and of course, in intergovernmental relations, there'll be an ethical component as well when we talk about mandates and grants from the federal government that are placed upon state and local governments. So this is a recurring theme throughout the entire program. Tonight was just kind of a little tip of the iceberg, a brief introduction to ethics and accountability in the public service. So at this point, let me ask you, I know I've talked for basically 3 hours tonight, save for a 10-minute break, and I do apologize for that, but any questions about either our coverage of the Constitution or any of these topics we have covered here in our discussion of accountability and ethics? If not, seeing that we are already past 9 o'clock, I'm sure you've all had very long days, and now you've listened to me for 3 hours, and so no one should be subjected to both of those things. So I would propose that we just kind of call it a night right now. I think this is probably good enough for this evening. Then I'm going to keep my promise of doing breakout groups. When we get together again the next Wednesday, we will start next Wednesday's session with breakout groups. And what I have envisioned for these breakout groups next week is I'll break you up into probably 3 different groups, or about 6 people in each group. And then what we will do is each group will come to kind of an agreement on identifying an example of an ethical violation that you are familiar with. And again, you don't have to use one from your organization. It can be on a much more micro level. So unfortunately, we have seen a lot of ethical violations in the news. We've seen ethical violations by administrators. We've seen a lot of ethical violations by politicians and by elected officials. So each group, between now and then, each person should think about some of these ethical stories, the ethical violations that you've seen in the news. And then when we get into our breakout groups, each group will then select one ethical violation example, if you will. And then for that example, I would like each group to think about those 8 different principles in the ASPA Code of Ethics and which of those principles your group feels was violated by that ethical violation. So that's kind of what we'll do in those breakout groups. So between now and next week, just think about some of those ethical violations you've seen or heard of, and then we'll have each group come to an agreement on the one they're going to talk about. The way I usually do breakout groups is I'll set you up in groups. You'll go out, you'll work together in groups for about half an hour. Then we'll reconvene in the class, and then each group will share what they came up with. And then once we're done with that next week, then we will move into our discussion of the differences between public and private organizations. So please, before next week, if you can, make sure to read the Graham Allison article in the classics textbook, the one that's called Public-Private Administration, I think something like that. Are they alike in all unimportant respects? It's in the classics book, in the Shaffert's book. Please read that one because that will form the basis of our discussion of the major differences between public and private organizations and public and private sectors. We'll talk about that next week. And then if we have time, we'll work ahead a little bit and really start to get into this discussion of what is public administration? Is public administration a discipline or a field of study? And then how do we know if it's a discipline or a field of study? The name on that article is by Graham Allison, and it's in the classics text. And I don't have my glasses on, but let me look through the classics text really quick and get the actual name of it. The actual name of it is Public and Private Management, Are They Fundamentally Alike in All Unimportant Respects? Wow, I got it right. And that's, I believe in the newest version of the classics text, it's article number 36, and it's on page 384. That's by Graham Allison. It's one of my favorite articles because I think Allison does a really nice job of kind of creating a typology of here are the similarities between public and private organizations, and then here are the differences. And then I think he makes a pretty compelling argument that there are some important similarities, but in terms of the functions and what the different sectors do, it's really in how they do them that is really what distinguishes between public and private sectors. So, and that also is an article that you'll use then as the basis for Canvas essay number 3. But we'll worry about Canvas essay number 3 once we get done with Canvas essay number 2. So for next week, you have Canvas essay number 2 and your 2 responses to classmates. I went through all the responses to Canvas essay 1, all well done, what I was looking for. And so just kind of repeat your approach that you used in Canvas essay number 1, repeat that for Canvas essay number 2, and you should be in fine shape. And then also your initial skills self-assessment needs to be submitted next week as well. Okay. Let's see. Chapter 1 and chapter we just read. No, that's just like background information for what we discussed tonight. So no, I don't think the only thing that may come back to you is when you're doing the midterm assessment, you're talking about ethics and you're doing that ethics scenario. There may be a place where you can incorporate the Bennington and Moore article into your answer, but nothing right now. That would be something that you could think about doing for the midterm assessment. So whenever I have the information, the chapters from Kettle's textbook, that's background information that will just help prepare you for what we talk about in our Wednesday night sessions.
I do have one more question, sir. On the introduction post, I see a calendar next to the portion where I went on course summary, but I can't figure out if I did it or not. I thought I did, but it doesn't show it. When I click on introduction post, it shows me a calendar.
You should be able, when you click on that link, you should be able to see everyone else's post, and they should all kind of listed in a line. Let me do this real quick. Let me see if I'm still in the Canvas site. Of course I'm not. So here, let me share my screen. And let me stop that. Let me see that anymore. Okay, and let me share out our Canvas site. Okay. This is mine, so let me put in student view. Okay, we get the nice, I get the nice purple color when it goes in student view. So when you're doing your introductory post, you should be able to see everyone else's. So if you click on introduction due by January 29th, that should pop up and you should see everyone else's post here. And you should be able to just hit reply and just post right there. So yeah, you're on there. I see you.
Okay, perfect.
So you're good. Yep, you're good.
Awesome. Thank you.
Sure. All good. And since we are here, let me just go ahead and show you under modules. I mentioned to you that I put that video from Kelly Janicek, our university librarian. It's right here under week number 2. It's this link here. You click on that and you'll then get her video. Again, it's about a little bit under an hour, but it's a really good video to give you some introduction to doing research in public administration. Sorry, Samantha has a question in text chat. Where can I find the Bennington and Moore article? It is should be in the classics textbook. I hope it was not removed, but it is article number 54 in the classics textbook on page, wow, I need my glasses, 596. It's called Public Value Theory and Practice by John Bennington and Mark H. Moore. So it's number 54 in the classics text. Sure, my pleasure. Okay, if there's nothing else, I'll go ahead and I'll have this recording up on our Canvas site by tomorrow morning and go back and review any of this information as you wish. Then we'll be back together again next Wednesday, start with breakout groups, and then move into a discussion of public and private sector differences. So have a good night, everyone. Hope you stay dry and this rain gets over very quickly, and I'll talk to you next week. So take care.
Thank you.
Thank you, everyone.
Thank you, Dr. Powell.
Thanks.
Thank you.